more than 2 meters apart, but at the minute he's not able to connect his sound, so he will join us as soon as he's available. Can I first of all check, can everybody hear me? Can you give a wave? No, there's still, I'm only viewing a few of you, so there's still a few more to join. Can I ask, if you're not participating in today's inquiry, if you could switch off your audio and your video, please?
Could I mention that Miss Spence appears to have logged in twice? I can see 2 pictures of her. And indeed, her name appears 3 times in the participant list.
I see that. Hopefully, thank you. I'll ask Callum and our IT support if he can. Oh, getting a lot of
feedback.
Feedback there. Everybody else got their sound off. Miss Spence, would you be able to switch your video off, as you're not participating in? Sorry, I can't hear you. You'll need to put your audio on if you want to speak.
Muted, Miss Spence.
Sorry, try again, Miss Spence.
Miss Spence, you're muted.
Miss Spence, we can't hear what you're saying. You're still on mute. Still can't hear you. If there's an issue, you could maybe email Jane at the DPA case officer. Apologies, that's a fire alarm at our end, but it's just a test. We'll just wait for the ringing to stop. Okay, apologies about that. We had been told that would take place at 10 a.m., but unfortunately you had to experience that. Right. Okay, now I'm still not viewing all the parties. We've got Mr. Campbell and Ms. Slobin from the council. I see Dr. Connor. The applicant, or
Mute me for a second. Good morning, ma'am. Ewan McLeod from Shepherd and Wedderburn.
Morning, Ewan. And if your witness still with you the same way that worked yesterday?
He is, yes. He's sitting at more than 2 meters to my left.
Right, thank you. Okay. I think that's all we need. I'll wait for Miss Spence, I think, is on the phone to the reception, but we'll plough on and get started. So yes, for the benefit of those who didn't attend the preliminary session on Monday, and for anybody watching on the webcast, my name's Alison Kirkwood. I'm one of the reporters appointed by ministers to report to them in relation to the application for the proposed Arecleoch wind farm extension. My fellow reporter David Liddle was also taking part in the inquiry, but though I will take the lead today, and hopefully David's sound issues will have been resolved, so he may chip in at various points throughout today. Inquiry sessions is scheduled to last 2 days, today and tomorrow, and will cover hydrology and private water supply matters. I won't go through the same formalities as we did at the preliminary session on Monday. This can be viewed on the DPA website for anybody who is interested. These inquiry sessions are also being recorded and will be available on the website. Just a reminder, when you're not speaking, please have your microphone off, and for anyone just observing, please have your camera off as well. It allows the connections to be maximised. If you need to attract my attention at any point during proceedings, please raise your hand or speak out if I don't notice. David and I will both try and keep an eye on people looking to raise attention. We'll have a short break sometime this morning, and then we'll stop again for lunch around 12ish. The afternoon session, we'll have another break, and we'll hopefully start around 4. Obviously, depending how we're getting on, and we'll choose a appropriate time to stop before picking up again tomorrow. Can I first ask participants to introduce themselves, just to make sure everybody knows who's involved? So the applicant first, Mr. MacLeod, you want to introduce yourself and your witness?
Yes, certainly. Good morning, ma'am. Morning, sir. My name is Ewan MacLeod. I'm a solicitor with Shepherd and Wedderburn, and I'm representing the applicant at this inquiry session. I've got one witness, who's Mr. Gordon Robb. He has a precognition that everybody will have seen, and I think with the wonders of technology, we might be able to switch to him.
Excellent.
Good morning.
Morning, Mr. Robb. The council, Mr. Campbell.
Good morning, ma'am. Good morning, sir. Colleagues. I'm John Campbell. I'm a Queen's Counsel at the Scottish Bar. I'm representing South Ayrshire Council with the assistance today of Ms. Connie Lobban, who you'll see on your screen. And she is the only witness for the council today.
Thank you. Dr. Connor.
Good morning, ma'am. Good morning, sir. Good morning, everybody else. I'm representing Miss Susan Crosswaite and several other third parties with private water supply interests.
Okay. Thank you. Ms. Crosswaite is present, I see, but is not participating. Dr. Connor will be giving the evidence for Ms. Crosswaite. Now, we agreed that the evidence would be given in the following order. The council first, followed by Dr. Connor, and then the applicant. Each witness will give their evidence in chief, and then will be cross-examined by opposing parties. David and I may then have some questions, and this will then be followed by re-examination. Closing submissions in writing will be taken at the end of all the oral sessions in the middle of February. We also agreed that precognitions would be taken as read. We'd ask that evidence given and cross-examination focus on those matters that are in dispute as set out in the opposing parties' inquiry reports and precognitions. Please note that David and I may intervene if we consider we're straying into matters that we don't need to include in our report. Dr. Connor, you'll be undertaking your own examination in chief. You don't obviously have an advocate or solicitor to lead you. So this provides you with the opportunity to either highlight points from your precognition or respond to matters raised in Mr. Robb's precognition. Also a reminder to everyone that re-examination should not introduce new evidence. Thank you very much to everyone for submitting your list of documents in advance. We will allow time between witnesses to enable participants to have the relevant documents to hand. Are there any other procedural issues we need to discuss before we get started?
Not so far as I'm concerned, ma'am. Thank you.
Mr. MacLeod, any procedural issues you want to raise before we get started?
No, ma'am, nothing from my perspective. Thank you.
Okay, Dr. Connor?
No, that's fine. I'm sure you'll keep me straight. Thank you.
Okay, well, on that basis, can I invite Mr. Campbell to introduce his witness?
Thank you, sir. Can I introduce to the inquiry Ms. Connie Lobban, who's an environmental enforcement officer with the Environmental Health Department of my client council. Good morning, Ms. Lobban. Make sure we can hear you.
Good morning.
Thank you. If you'd have in front of you your precognition and your inquiry report to start with, and also the map which you produced, which I think is 16.8, CD 16.8. The precognitions have been taken as read, but I would like you to read paragraph 3 of your precognition, please, just so we can understand who you are.
Okay. Good morning. I'm Connie Loban of Environmental Health and South Ayrshire Council. I work as an officer and enforcement officer. My work, I have extensive experience of outdoor leadership, having been a volunteer group leader throughout East Ayrshire Council through the Bar Hill Centre in previous years. I've lived for a good part of my life in properties which are solely reliant on private water supply, and I'm from a farming background. I'm giving evidence as an authorised officer for South Ayrshire Council Environmental Health as required as part of the Council's objection to the application. As part of my work remit, I have responsibility for the private water sampling, the risk assessing, the supplies and the supply of properties, the grant applications, which are numerous, frequent field visits, which carry out throughout the year, 12 months of the year, keeping of the databases up to date, ensuring that the relevant legislation is being adhered to by all parties involved in the processes. I engage in liaising with property and supply owners, the supply users and the potential developers, whoever they might be, not just wind farms. Outside agencies, liaising with outside agencies, the public health bodies, community groups, business owners and other local authorities.
May I ask you to pause there? Do you have any dialogue or liaison with the DWQR, the Director of Water Quality?
As Environmental Health Service is in regular contact with DWQR for obvious reasons, because they're the legislative body and our legislation's worked through the DWQR in Edinburgh in the Scottish Government Office. And yes, I do have regular contact and updates in the DWQR. In fact, putting examples of problems across to the offices on a regular basis.
Do you have any involvement personally in the formulation of policy or guidance?
I have had input towards updates of the Private Water Supply 2017 regulations, as have other officers. It's not just me, it's other officers in local authorities in Scotland. There was a small group formed to look at the robustness, the actual legislation, shall we say, and similar problems were being encountered. It appeared that similar problems were and are being encountered throughout Scotland on private water supplies, not necessarily to do with wind farms, but to do with protection and working with users who quite often take their supplies from other privately owned land or other people's land. So we looked at the legislation. The legislation was updated in 2017, which brought in a duty of care in paragraphs 16 and 17. I've also been involved in sending examples through of problems encountered in private water supplies to the DWQR with a view to the European directive. And I believe that the European directive was adopted yesterday. Hopefully it will then transpose into Scottish legislation through the Keeping Pace bill, which I can't remember the name of. But yes, there's quite a lot of input, and it's not just myself, but I am involved, or I have been involved.
For how many years?
Full-time with private water supplies since 2014, and assisting the private water supplies since 2008.
Thank you. We don't need you to read, I don't need you to read the last two paragraphs of paragraph 3. If we could, ma'am, if we could just take those as read. I think just for confirmation, you prepared an inquiry report, which is CD 16.9, and in that report you address various aspects of this development and also the management and policing of private water supplies. Is that correct?
Yes, I don't have a CD though.
No, that's all right. If you have a paper copy, just for the reporter's notes, it's CD 16.9. If you have a paper copy of that report, I'd like to cut to the chase, please, and ask you to go to, first of all, paragraph 10, which is on page 5.
Yeah, land and property.
That's it, land and property out of reach. What's the significance of property which is out of reach of public water supplies in the connection which we are discussing here?
That's a critical factor, actually. Property that's out of reach of public supply has the potential to never be connected to mains water. That's it. That's the critical factor. If they're left without water, if properties are left without a suitable potable water supply, they fall below what's classed tolerable standard under environmental health, and the property can be served with notice. The owners or the people who own the properties can be served with notice and closure, which effectively the house cannot be used for living in.
Right.
So if you don't have it's deemed one of the critical factors of a suitable habitable abode.
A potable water supply being one of those factors.
Potable water supply, yes, for human consumption.
Right. So, turning then to paragraph 11, you say it's noted on the development areas map and the layout map that there are 2 entrances marked, one at Arnameen Bridge, which passes Arnameen Smallholding, and the other at Bent's Farm. Ma'am, I wonder if I could ask you and Mr. Little if you've had a chance to look at the map CD 16.8 and if you're familiar with these locations.
I'm very familiar because I...
Sorry, I beg your pardon. I'm asking the reporter. Just bear with me. Ma'am, you're muted. I'm sorry. I just want to avoid taking evidence that you are aware of already. If you're familiar with these locations, I won't bother with the witness to take you to them. But if you're not familiar, then I'll have to do that. Can the reporter please tell me if she is familiar with these locations? I'm sorry, ma'am, I'm not hearing you.
Yeah, I think you're less than a second. Well, up entrance.
Well, if I may then, if I may then,
There's a point of clarification, then it might be worthwhile you take the briefing.
thank you. It seems there's a little bit of technology issues with your, but I did get the sense of what you're saying. Can you just confirm that you can hear me, ma'am, please? Even though you yourself are inaudible, but thank you. Connie, can you hear me all right?
Apologies, I'm able to, I'm back on now in terms of being able to.
Good. Ms. Lobban, if you have the map in front of you, 16.8, please. You have that?
I have hard copies, John, so
Hard copy is fine.
hard
Um,
copies.
Can we see the A? If you just listen to my questions, can you see the A714 running from the center, the top of the page down to the center on the right-hand edge?
Yes.
And just north of halfway, can we see the village of Bar Hill?
Yes.
Now, thinking about these entrances to the site, if we take the northmost one first, 714, where it appears below the top edge of the plan.
Yes.
And that's one of the entrances that you refer to in your report. Is that correct?
That's correct, yes. The Bent's
Which one?
Farm.
Which one is that?
Bent's Farm.
Bent's Farm.
Entrance.
Thank you. If we then pass down the A714 in a generally southeasterly direction to the middle of the right-hand edge of the page, we can see another entrance with a blue dot at it. What's that called?
That's the Arnimeen Bridge entrance.
Right. Now, may I take these one at a time, please?
Yes.
And ask you, first of all, about the Bent's Farm entrance. Does it have any particular characteristics as far as you're concerned?
It has several, as far as I'm aware. The entrance is in below a railway bridge, and I believe that there has been application for, shall we say, construction to go ahead and below that before. It's a very narrow, small entrance. The entrance is also crossing across ground which is above the White Cairn private water supply, which you'll see to the right hand side on the map as a purple dot with the blue, the green blue marker on it. Several water courses here, boggy land down towards the railway side.
Is there a working farm at Bent's Farm?
There is a working farm at Bent's Farm. There's an access route there for other farms like Kilrenny, for example, on the hillside, and the land associated with that, the working farms.
Right. And what kind of farm is it?
As far as I'm aware, it's beef farm. I haven't had the necessity to visit the particular farm or the house, Bent itself. Kilrenny, I did speak to the people at Kilrenny, although I don't think it will be hydrologically connected. I can't say that for certain, but I don't think it will be on the hillside. However, the actual road, the access road that's proposed there, is partly used or shared by them. I don't know what the legalities are for it.
Okay.
It's beef farm as far as I'm aware, beef and sheep.
It's not an arable farm then, it's a stock farm, is it?
As far as I'm aware, it's a stock farm.
As far as you're aware, does it have a private water supply?
Kilrenny does have a private water supply, yes.
Does it have the option of a public water supply?
No, that won't have the option. Because of situation, because of placement.
And where we see on this map the road marked from the Bent's Farm entrance to the wind farm site, that's a double red line with a black line in between.
Yes.
Does that road exist at the moment or not?
It may well be forestry access. I don't know. I've never been on that track, shall we say. The road certainly exists to below. There is a Tarmacadam road to below the railway bridge.
Okay.
as I said, it is a narrow entrance. For the farmers to get stock, for example, out to markets, they have to park the roadside of the railway and then take their animals under the railway and then put them onto the floats or decant them off the floats and take them under the railway. So it won't take a high vehicle at present, so that would be, it would need altering, shall we say.
Sorry, are you telling us that the railway bridge is going to need alteration in order
It may need altered, depending on the size of vehicles that we're going to be using. It may not be big vehicles, I don't know. Possibility.
Okay. Right. Okay, thank you. Now, could we just logically go then to the other entrance, which is at Arnameen, which we see on the right-hand edge of the plan. You see that?
Yes.
And again, we see the same legend for a road which passes generally southwesterly direction to the entrance to the wind farm site. A much longer route in. First of all, then, to ask you the same question, does the Arnameen entrance to the site have any particular characteristics?
Yes, I would say this is the one of most concern to myself. Not that the others not of concern at Bent's Farm, however, this has great concern, possibly of cumulative effect as well, not just from Arecleoch extension. However, the road is in place, and this was an entrance for the Arecleoch wind farm itself. Arnameen, Burnside, several properties, forestry removal round about the Corbar area as well. A lot of the properties lying along here, there's borrow pits, marked borrow pit 2, borrow pit 3. Yeah, great concern because of the amount of traffic there will be, the cumulative effect for Chimney, which is proposed, using the same access route as Arecleoch extension. The borrow pits in use. I know that there was a dislike of using the term quarries, but essentially, if you take rock from the earth, you have to quarry it out, blast it. So blasting and crushing and processing of rock, disturbance of ground, widening of roads, strengthening of certain areas perhaps. Yes, it causes great concern.
Okay, now on this map, thank you for that. On this map, we can see to the south of the A714, a generally lozenge-shaped area with a red line around it and hatched diagonally in orange.
Yes.
See that? And in the predominantly borehole PWS users. Yes?
Yes,
And are you the author of this map?
I am, yes.
Thank you. How do you come to delineate the area of predominantly borehole PWS users in the way you have done here?
Great difficulty. I'm not a qualified hydrologist. I'm not a qualified hydrogeologist. Simply by trying to risk assess, as we do for the private water supplies, information from the owners themselves, or the people or the users, depending on which property we're in, at the time visiting, from previous information gathered, such as disturbance that might have occurred or incidents that may have shown or been imminent at the time. Problems arise, and we are then contacted by worried owners or worried users. Generally visiting the area, John, is how we look at it, and we have to make an assumption somehow because the law requires us to do the risk assessment and do it to our best of our ability.
And Miss Lobban, have you visited the locations marked here with either a blue dot or a blue star?
Yes, I have.
The purple dots are what?
What are the properties? Oh, sorry.
I think the blue dots are the properties according to the legend.
Dots are the properties. The purple dots will be the boreholes, and the stars will be surface or what. I'm just trying to bring my maps up now. I've got the layers here. The stars, the blue stars, are the private water supplies, the farms and businesses. They're reliant for water. And that green, I might add at the bottom, should have the star there as well. That's been omitted, I see.
I mean, at the roadside, at the side of the A714.
At the very start of the access is missing the star. I'm sorry, I've omitted that. But that is it.
What's the nature of the business that's carried on there?
At Tarney, it's a tourist business by a young couple who are going to be doing bed and breakfast and tourist yurt accommodation, dark skies.
Is that by way of being exotic camping?
No, I don't know what exotic camping is. Never done it. Only ever had a tent.
I'm not sure I know what a yurt is, but anyway.
Yeah, a jar, a Mongolian habitation.
Okay, well, we can look it up in our own time. Now, you maybe ask some questions, Ms. Lobban, about the red line around this, what you call predominantly borehole PWS area. Mm-hmm. So I'd just like to be clear with you about the methodology that you employed in placing the line where you have placed it.
Right, the area in question is, we feel there's not sufficient evidence to prove that there won't be damage to the private water supplies in this particular area. Where do boreholes take their water from? Is there a solid proof of where the water originates? The depths, different depths of boreholes from artesian wells, very deep, old water. For example, I lived on an artesian well myself for a period of a number of years, and when it was sampled, we were told by the lab that the water was probably around 1,000 years old. The potential to have contaminated water at a much later date is certainly present with boreholes, even though people think bore wells are deep and they probably won't be affected by possible contamination.
Now, let's look further at the drawing which you've produced within the red line area, which I understand to be indicative. There are a series of lozenge-shaped areas circumscribed in orange.
Yes.
Can you see that? And although the reproduction isn't very good on my copy, I think we have horizontal hatching. Is that correct?
There is. Yes.
And those are described in the legend as source catchments.
Yes.
Now, these are smaller areas, and once again, are you the author of are you the person who's placed these source catchments where we see them in the drawing?
I am, yes.
How have you come to that information?
Again, through visiting the sites, speaking with the owners, looking at the ground, and trying to make an assessment of where the catchment areas and the water may come from. In some cases, following lines of tributaries to see where the source is, try and ascertain source. It can be extremely difficult doing this in remote rural areas.
Can it be done from a desktop study?
some information can be gleaned from desktop studies, but really to get a true flavour, to get the real desktop studies as well, will be pertinent at the time they're written, I assume. If you go out onto land, quite often you find the differences. And I find that every single week of my working life. Going out onto the land, going to the properties, and something's changed, something's different. Simple things like forestry, for example, as we have proposed here for, well, trees have to come down to enable the construction to go ahead. Property owners have changed and they haven't told information, or they've changed their business, or they've created a business and we're not aware. So things change. Things change.
Where we see these orange lines around lozenge-shaped areas, how dependent is the position of those lines on actual topography on the land? Now, clearly, water doesn't flow uphill, at least not usually.
Not usually.
Do we depend on topography for an understanding of where the source area is, either a point source or a diffuse source?
Yeah, topography has got a heavy weight behind it, depending on the type of ground that we have. We're encountering for the private water supply, particularly boggy ground. People look as bog. Many people look at bog areas and think, that should be okay, it'll be a good filter, the water will filter through, not going anywhere. However, when you've got heavy machinery or construction or disturbance to land, you can get side wash. It depends on the ground that's sitting below. The actual bog, is it peat, is it gravel, is it silt, what type of ground is it? Again, I'm not a hydrologist, I'm not a geologist, and I'm not a hydrogeologist, but when you're walking out, you can get a good, when you're actually doing a physical site visit, you get a really good idea of what the water supply is like. For example, Lagish, Dochroyal Farm, Dochroyal, the Dochroyal area sits in a basin. Now, it's not very evident unless you really know maps inside out, but the maps are good here, but it's better when you're out on the land to get a really good idea of how low they sit in comparison to everything else. It doesn't seem much, 10 metres, 20 metres, doesn't seem much. However, it can be the difference of pollution getting to a property or not. Lagish, for example, sits on the Lagish Burn. If you follow the tributary,
can we find it on that? Forgive me interrupting you. Can we find it on the map, please? Sorry, can we locate it on the map, please?
how am I going to do this?
Well,
right.
start in the center. Start in the center of the map and tell me which direction to look in.
Center of the map, we have Lagish with a little purple dot and a star on top of it. If you look to the proposed turbine 13 and go to your right hand side, and you'll see 3 hatched areas, 2 round circles and an elongated hatched area. Can you see them on the map?
Yeah.
Okay. The bottom, the third one, the long elongated one with the star below it, is Lagish. Right. And above that, you have Dochroyal Cottage and Dochroyal Farm.
Okay.
Lagish, if you take Lagish down, the dot on top of the star. I'm sorry, the maps maybe not just come out just as clear as I'd wanted, but these tributaries round there, this area heavily relies on a mixture of different water down there, and surface water does play a big part in the supply to Lagish and to Dochroyal Farm. Although the owners do maintain they have wells, and I would agree they do have wells at the sides of their properties. However, I would say they're a mixture of seep wells and of water coming in. They're so old, they're ancient water supplies, these, and we come across this all the time in water supplies. And I won't just say Scotland, I'll say the UK as a whole, but Scotland, certainly in rural areas, you come across water supplies which are very, very old, very ancient, and finding where the water comes from is extremely difficult. And it's now, I would say, the climate, we're being told is climate change is happening, and we're getting mixtures of extremely heavy downpour rain for days and ends, weeks and ends sometimes, and then we're going into periods of drought. This is when we're starting now, and only now in the past few years, to realise where water comes from. A lot of the properties, not necessarily just in Bar Hill, but very good examples are being shown. So much so that the DWQ and SEPA are now charting this. And with this in mind, the Scottish Government ordered Scottish Water, and I know this is not part of my submission, but Scottish Water the Scottish Government ordered Scottish Water to hand out emergency water because private water supplies in some areas are experiencing drought to the point they run out. There's no water. So we have to have this in the forefront of our minds now going forward. It's critical. And that, coupled with change to the land that has a potential to pollute and contaminate water, possibly for all time, and I'm not talking just about bacterial contamination here. Bore pits, if you want to call them, where rock is realised, or quarries, or blasting, disturbance for bases for turbines, trenching for cabling, any kind of disturbance to rock can, and certain soils can release non-soluble pollutants, poisons into the water, which will render private water supplies useless forever, that you can't use them again. So we have these potentials here. I'm not saying it's going to happen, but what I am saying is environmental health view is protect the water supplies. We support, protect, and as a last resort, we want to enforce. We don't want to enforce. We'd rather look at solutions in the first instance. And if that solution is to remove turbines or to remove bore pits from the plan, or to change or to remove access roads, then that's what we would advocate.
Thank you. That's a very helpful answer. A couple of points arising from it. You used the expression sidewash. What do you mean by that?
Well, you said about yourself about the topography. Water doesn't run uphill. That's correct. No, usually, unless you get engineering involved. But water can go sideways, and if you have shallow, boggy earth on top of solid rock, it can be pushed sideways. And we've looked at various different types of earth and ground makeup over the years for various applications and for risk assessments. And water can get pushed sideways. So although certain soils can be good, we see it in tanks, we see it on the ground, where soils absorb pollutants. It can be a good filter. However, there's only so much filtering earth can do. And if you have sidewash where large vehicles, and I'm not talking about large lorries, we have huge vehicles accessing these sites with front drive and rear wheel drive and enormous long loads on them, really heavy, abnormally heavy, compared to perhaps the vehicles that were used to put the forestry in the first place 50, 60, 70 years before. And these vehicles can create movement, and it moves water and anything else that's not solid sideways. You can push it into tributaries or down into sources, into catchment areas. It has the potential for it.
Thank you. That's clear. I think I understand that whether the source of water is a spring or whether it's a diffuse source, say from a bog, that in general water is collected at each property in a cistern or a tank before it's fed into the consumer.
Generally, yes, not always. Sometimes, and we do come across it, there's a pipe into the earth and it goes straight into the house. Well, on the earth, shall I say, in the collecting surface, it's usually surface water, but I have seen it with spring water as well, where we define the spring as popping out, literally popping, a natural spring popping out of the earth. So usually it's collected in tanks, yes.
Okay.
Collection tank or a holding tank, or a series of such.
Right, now can I move on then, going back to your report. Ma'am, it's 10 to 11. I don't know when you plan to take a break, but I'm not in any hurry for one, but if you are, then please say. Going back to your report.
I think we're okay for now. We'll see how you get on with Miss Loban, and maybe take a break after you've finished your examination in chief.
Thank you. Perhaps more quickly, Ms. Lowen, at 12 of your inquiry report, you list a number of things as bullet points, which you say were omitted from the environmental impact assessment report. Is that right?
Is this under new development, John? Am I in the correct
Yes.
report?
Yeah.
Yes.
So does that mean you haven't been able to find evidence about all of those things?
Yes, that's correct. New infrastructure. If you're looking at the maps provided, yes. I'm looking to my side here, just excuse me. Yep. Arecleoch wind farm at present is up, but the proposed wind farm extension would need, they cannot do without new turbines, new clean pad hard standings, the basis for the turbines themselves, transformers, switchgear housing. They'll need to upgrade track and access, and they'll need to probably look at and possibly upgrade the water crossings as well. There is stated there's going to be underground cabling, which will require trenching, and I don't know if most of you understand trenching, but it is a very deep trench that's cut into the ground, meters deep, to keep the cable underground. It can go for miles as well, not just, I mean, for example, the one connecting another wind farm, Kilgallick, went for miles. It's away down past Maybole, I believe. Miles and miles and miles it goes for. New substation and the compounds and associated things with that, sewage and water and whatever is necessary. CCTV masts and cabling throughout the site for safety, because there's a lot of very expensive, very a lot of expensive equipment on site. Some people know, some people don't, so as well to safeguard the actual site itself. Then you've got your temporary buildings which will be put on and taken off, and again the search area for up to 6 borrow pits. Although it says the search area for 6 borrow pits, I do believe that some of the borrow pits have been used previously for Arecleoch wind farm building construction, and some have been used for forestry, for access roads.
Can we turn to that section then? We turn to that section. You've touched from time to time on borrow pits, which you say are actually stone quarries. And are you telling us now that there are borrow pits in existence which were used for the previous wind farm at Arecleoch?
As far as I'm aware, yes, they are. And certainly in question, borrow pit 2 and borrow pit 3, we had a request for help a few years ago, it wasn't myself who responded right enough, it was a different officer. But when it was maintained that when blasting was occurring at Borrowpit 2 for the Arecleoch wind farm construction, that the water was being disturbed at Wood Park Farm. And
could we locate that on the map, please?
right, Arnimeen, I suppose going to Arnimeen Bridge would be the easiest. And if you go to Arnimeen Bridge and then you come across to the left-hand side, you'll see on the A714, you'll see 3 blue dots. If you come down from them to the left and down, you'll see the purple dot with the blue star.
Yes.
Have you located that?
Yep.
Within that kind of oval-shaped hatched area, there's 2 purple dots and one has a star, and the one with the star is Wood Park Farm. And this is an active working farm, smallholding.
What kind of farm? A stock farm again, is it?
Stock farm, beef and sheep, yes.
Yep.
And he has, the owner has quite a number of, an area of land belonging to the farm in a T shape to the farm itself.
Okay, well, no doubt we can look at that on site inspection. I'd like to ask you, please, about the paragraph in 13 of your inquiry report, the 3rd paragraph, which begins, "We also have concerns." Do you see that?
Yes, I do.
In the second, I beg your pardon, 3rd sentence, you say, "Borrowpits 1, 5, and 4 may have the potential to cause a detrimental effect on properties that take surface water sources."
Yes.
I'd like to know, please, what the basis is for that statement.
I've made the statement because they are up gradient and on tributaries, which the whole area feeds into various different burns for the Bar Hill Rail Station, Ward of Cairnlea and Ferngate. Ferngate and Bar Hill Rail Station are on the same supply.
Private supplies for a railway station.
It's for the railway station and it's for use by their staff and anyone who visits, any other workers and companies who visit, because they have regular inspections of the lines, if you can imagine. Ferngate is the house next to it and it's a private owner. And Ward of Cairnlea is across the road from Ferngate and Bar Hill Rail Station. And again, that's a privately owned property. But they all take their water from the Crosswater burn. And the Crosswater has so many tributaries that the area is, that is really an area that has to be visited to understand the topography there, John. For the number of burns flowing into each other there. It is a forested area. It is due for felling at the site because of the age of the trees, I would imagine so. But the flow of water is enormous. In the summertime, this summer when I was sampling, was one of the lowest I've seen on the water flowing in the burns. It was low, but it never stops. But the potential for these borrow pits cannot discount the potential of 1, 4 and 5 because of their placement. That coupled the cumulative effect of the introduction of the new access roads. Now, you may say they're not new, there may be access roads there already. However, for the type of felling that's going to be required, the type of removal that's going to be required, the type of vehicles that are going to be required, and then on to the construction. Again, the roads will, for all necessity, the roads will need to be renewed, basically. I would think the access roads internally and introduced in certain areas, new points in there.
In this paragraph, in this paragraph, Ms. Lubben, you,
Can I just say also, John, that the cumulative effect here is not just from Arecleoch extension either, because we have the proposal of Chirmery, which has been accepted, and they will need access in here to a point on the railway where the railway bridge is already there, taking over water, where you can pass over the railway. Sorry, the bridge is there for traffic to take the traffic over the railway itself, and they're going to have to upgrade that as well for the Chirmery wind farm. So there's going to be a huge amount of work and disturbance in this area, and to introduce borrow pits, which essentially are taking rock for the wind farm, which could be gotten from quarries locally.
okay. You use the word vulnerable once or twice in this paragraph. I'd just like to explore with you, please, what you mean by vulnerable or vulnerability in this context. What makes one PWS more vulnerable than another?
The vulnerability lies in the rural situation, the topography, and exposure, I expect. A lot of the private water supplies, as you've seen going across the map, they're vulnerable because they will never have the opportunity to go on mains unless Scottish Water decides to put mains into the area, which is not going to happen, I don't think. There's no mains in that area down the A714. There's no mains water at all. There's no mains water near Lagish or Dockroyals. There's no mains water up near Chirmery or Burnside. All of these properties are extremely vulnerable, and the critical factor they're all relying on is water for human consumption. The vulnerability of this particular area, again, comes back to the type of ground. I've walked the ground. I've been there on risk assessments with other officers from environmental health. I've been out with representatives of the railways, of, it's not ScotRail, I can't remember the name of the company, to look at the tank, the collection tank for Bar Hill, for the Ferngate supply for the Bar Hill rail station and for Ferngate. And also we looked at the tributaries and possible causes of pollution, because we had bacterial readings. So the area, I would say the vulnerability comes from a mixture of factors.
Okay.
But the type of ground.
Right. Thank you. I'd like to go now to paragraph 17 of your inquiry report. Do you have that?
Yes, yes.
Now, there's a list of properties here signified by bullet points, and then there's a second list. And I'd just like to understand how you came to compile these two lists as briefly as you can, please.
Right. Well, the opening sentence, it's our opinion due to the remoteness of some of the properties solely reliant on private water supplies, says it all. These properties in the first list are solely and totally reliant on private water supply. They will never be in the mains. They're not on the mains, they won't be on the mains in the future. There is no mains in the area. The vulnerability comes from the type of land and the remoteness of the area. It's basically our advice to private water supply owners are, if it ain't broke, don't fix it. In other words, if there's no problems, don't introduce change, and if there's drought, do not go digging trying to find another water supply, because you may cut off your original supply without knowing about it. So the vulnerability, serious change coming in, such as the large construction and the cumulative effects of other construction and traffic and vehicles and movement and disturbance, basically. has the potential to be destructive, not just to temporarily pollute, but to completely wipe out private water supplies, as I have personally seen. Not necessarily wind farms, but I have personally seen private water supplies stop because of change.
And again, just briefly, the second list, please.
The second list, the catchment areas for the second list are quite distant from the properties, such as the Altercanachs, West Altercanach and East Altercanach, working farms, rented out properties, Glen Alty House, a business, Glen Alty Cottage, a tourist business. They all rely on what we call the Altercanach supply. And again, it's a great distance away from the actual properties themselves. Glen Alty Cottage also has a bore well, which is having difficulties at the present time, and they're now reliant on the other supply, the Glen Alty supply.
Can we just locate, forgive me interrupting you, can we just locate those on the plan, please?
Right.
Just in it with a general indication.
Bear with me. Right, you have the A714.
Yeah.
And if you go to Bar Hill.
Yeah.
And then go to the right hand side of Bar Hill and go down the A714, and the first two stars, you'll see the first two stars are the Glen Altys.
That's Glen Alty, right.
Glen Alty House and Glen Alty Cottage and then Glen Alty House. And then if you come down the map, you'll find Altercanach and East Altercanach. Now the one with the star is a working farm as well as a family residential house. The one to
That's
the
fine.
left.
That's fine. I just wanted to get the general location on the plan. We can deal with that in detail at a later stage in the inquiry.
Further down, you'll see the hatched area with a little purple cross, and that's where the source uptake is. It's not the source; it's the collection point for the water supply. It's a fair distance away.
It's just to the right of the very centre of the plan, then, is it?
That's right. It's above the Dock Royals.
I think that's dealt with in the legend, but anyway, above Dock Royal, yeah. Okay.
It's a single.
Thank you. Now, again, trying to move on because I think I've been long enough, really. Paragraph 19 of your report. You say that the premises listed there are not dealt with in the EIA. Is that right?
That's correct. Well, the EIA that I've got, yes, no, they're, as far as I could see, they were missing.
Okay. I'd like you now, and I think nearly finally, if you take up Mr. Robb's inquiry report, please, and turn to page 24, which is headed Conclusions. I'm sorry, ma'am, I haven't given you the number of that, but if I could just find it.
It's okay, I have it here, thanks.
Thank you. Do you have that, Ms. Lobban?
I do, yes. I'm trying. Page 24.
Page 24, headed Conclusions.
Got it.
I'd like you to look at paragraph 8.4. Sorry, 8.3, I beg your pardon. The author says, it has also been confirmed that excavations to establish turbine foundations and bore pits are unlikely to intercept significant quantities of groundwater or require significant dewatering. It is noted any limited dewatering associated with turbine foundations is temporary and as a result of the low permeability of the geology, limited in extent. There will be no long-term alteration of groundwater flow paths or levels, as no long-term groundwater control is required to maintain the wind farm infrastructure. Now, that paragraph perhaps takes a little deciphering, but it seems to be saying, doesn't it, that the use of bore pits is a safe expedient in this case. Do you agree with that?
No, I don't agree with that. I'm sorry. No, I don't agree. I think what he's trying to say here is it wouldn't have significant dewatering. That doesn't say it's not going to have no dewatering effect.
Can we understand? Can we understand? Forgive me interrupting. Can we understand that expression, dewatering?
Dewatering. Change of water course. Establishing the foundations. What do you do to establish turbine foundations? It will take, depending on the area, may need deforestation and then trenching to stop the area from flooding whilst whatever construction is required. The construction itself they're deep and they're quite wide, depending on the height of the turbines, depends on the size of the foundation required and how deep they're required to go. So it has potential to affect water flow. Dewatering, it could end up diverting water away from the areas that it flows at present, which could have a catastrophic effect on the catchment areas for the private water supplies.
Have you seen that happen?
I have seen that happen, yes.
Okay, thank you. I'd like to ask you a couple more points about this section. At 8.4, the author says, in the last sentence, the development footprint of the wind farm, when compared to the extent of the surface water catchments, is very small. And I think by implication, no, I mustn't ask you that, I'm sorry. Do you agree with that?
Well, I don't know how I can agree
Is it
with
important?
It is extremely important. The development footprint of the wind farm when compared to the extent of the surface water catchments is very small. How can one person or one compare a development footprint to the extent of the surface water catchments? The water catchments are critical to the properties, full stop. If the properties don't have potable drinking water, the properties cannot be inhabited. Full stop. So how can you put a development footprint comparing it to a water catchment and then say it's very small? It might be very small, but it might completely knock out the water supplies. It can be very small and not have any effect. How do we know this until it's built and it's too late? And this is what we're hoping that sense can prevail first and look at it in a more, I was going to say organic way, but maybe I shouldn't say that, to do with water. But how, no, sorry, I don't agree with it. I can't see how a development footprint of an enormous wind farm extension to already existing wind farms and the cumulative effect of others will be very small compared to the extent of the surface water catchments.
Okay, thank you.
Just, for example, a surface water catchment for likes of Dockrell Farm or Lagish Cottage, for example. There are two examples in the centre in this basin. I can give other examples. Corwars across the other side of the development, down the south side. Just taking one tributary out could mean the difference of a potable water supply 365 days of the year. One tributary missing could supply that extra water. Now, if water's diverted in any way, whether it's surface, whether it's underground, whether it's polluted, how can you say it won't have a big footprint? I'm at a loss to say how they can come to a conclusion like that. And I'm sorry, but I don't think there's enough evidence to prove that.
Right, thank you. At 8.6, the author says mitigation measures have been proposed to protect ground and surface water resources. Have you seen the catalogue of mitigation measures which are proposed?
I have, yes.
Are you satisfied with them?
No. No. Especially when the discussion of the Bar Hill rail station and Ferngate supplies, they missed out Ward of Cairnlea, but the Ferngate and the Bar Hill, to mitigate oil and diesel and water, to mitigate that, they proposed to put booms or something across one part of the water. I'm sorry, but the mitigation, we're talking about human health here and human consumption, and not just by one or two people. We're talking about families and tourism and people coming in from out with the area. It could be disastrous. The potential is disastrous. However, I'm not satisfied with the mitigation, no. Environmental health being to support, protect, and lastly to enforce. Rather than enforce, we would look at protecting, and if that protection means the removal of turbines and the removal of bore pits and removal of, or not going ahead with digging, construction and roads or trenching, that's what it should be. Potential for diesel to get into water, you might never get your water supply back.
Thank you. 8.10, which is over the page 25, please. With regard to B, says the author, it has been confirmed that the proposed development will not result in any significant effect on ground or surface water resources or private water supply sources. It has been confirmed. Have you seen that confirmation from anyone other than the applicant?
No, I don't. For me, I can't. I don't know that it won't result in any significant effect because of the resulting government here and introduction of other things coming in. So we cannot. I don't see how confirmation can be given.
So the author says will not result in any. Sorry, let me finish. Will not result in any significant effect on ground or surface water or private water supply sources. Any significant effect. Can I take it you don't agree with that?
I disagree with that. And I don't think there's enough proof there to show that it won't.
Right, Ms. Slobin, thank you. I have no more questions for the moment, and I expect Mr. MacLeod may have some questions. Ma'am, this may be an appropriate moment to take a break. It's up to you entirely, of course. But thank you very much, ma'am, for the opportunity to ask those questions. And thank you, Ms. Slobin.
Thank you.
Thank you, Mr. Campbell. Thank you, Ms. Lobben. I agree. We're on 11:18, so it's okay with all parties. We'll maybe take a 10-minute break. Come back at 12 minutes. Come back at 11:30 to start the cross-examination by Mr. MacLeod. Is that okay? If you just switch your video off and come back in 10 minutes, please. Okay, just waiting for a few more people to come back. Okay, I think that's the main participants. So if we're ready to start the cross-examination, Mr. McLeod, you got questions? Ms. Lobin, is that okay for you to start cross-examination now? Okay, thank you.
Sorry.
Thank you, ma'am. Good morning, Ms. Lobin. I wanted just to start by discussing the procedural history here, just very briefly, because originally, of course, the Council did not object to this application on the basis of impact on private water supplies. I wanted to understand, between your original non-objection and your decision to object, was there any change in national or council policy?
Not that I'm aware of, no.
Was
It may have
there
been,
any
but
change in Sorry, I'm not sure if you'd finished.
no, I'm saying there may have been, but I'm not aware of it.
But so certainly none that you're aware of that influenced your decision to object?
No.
Was there any change in legislation?
Not that I'm aware of. Well, there was possibly the introduction of the woodlands, the forestry guidance, but apart from that, no, not that I'm aware of.
But again, that's not a factor that influenced your decision to object?
No.
What discussions took place within or external to the council that led you to change your position?
External to the council, can you be more specific?
Involving external advisors, for example?
External advisors as in?
Any external advisors?
Well, John Campbell QC, I've discussed with him the extension at hand that we're discussing today. That's really about it.
Did Mr. Campbell encourage you to object?
Not necessarily, no. We were looking for advice on whether we could or not.
Whether you could object. So rather than assessing whether the evidence justified objection, you sought advice on whether you could object to this application on the basis of private water supply?
No, perhaps you've picked it up wrong. Looking at the application again, it was pretty obvious that we would object and we needed advice on whether we could object. And didn't go to John Campbell asking for advice and then he advised us to object.
So when you say looking at the application again...
Extension,
Yes. Let's go back to your original position of non-objection. Did you not consider the application information thoroughly before deciding not to object in the first place?
It wasn't me who put the original conditions through because I was absent at the point in time that was happening. But on return, looked at the Arecleoch extension, and had it been me who was writing it, I would have placed an objection at that point in time, based on the evidence and the knowledge that I have of previous applications in the area, not necessarily for the Arecleoch extension area, but certainly for the Bar Hill area, shall we say.
So it's basically, although it's not your formal decision to object, it was your decision to promote the objection because of your concerns?
Yes.
Yes. Okay.
Yes.
Now, the position that you've set out in your inquiry statement is that any risk of impact to private water supplies is too great. Are you aware of any national or local policy that supports that position?
The national policies, I'm new to this, so I don't really know where you're coming from on this. Ewan, if you could maybe explain what you're looking for.
Well, what I'm trying to understand, and what may be helpful for the reporters to understand, is whether your position is one that you alone hold, or whether, for example, there's a Scottish Government position that says any risk to private water supplies from wind farm construction is too great.
Right, thank you. No, it's not mine alone. It's the opinion of environmental health. My seniors as well, who have looked at the report with me, and it's also embedded into the 27 legislation, the water intended for human consumption, private supplies, Scotland, Scotland Regulations 2017, that the duty of care in paragraph 16 and 17 states quite clearly a person should not, the relevant person or a person should not contaminate or render the water contaminated in any way or disturb it through whatever means.
Yes, but you'll appreciate that the duty not to contaminate is different from a decision on whether any risk of contamination is too great.
Right. The risk done through the risk assessments, I'm assuming you're pointing towards the DWQR here, the Drinking Water Quality Regulator, or bodies such as that. Is that correct?
Well, I appreciate you're, as you say, you're new to it. So the way it works is I ask you questions, you don't ask me the questions. Mr. Campbell can ask my witness questions in due course. But really, all I'm trying to understand at the moment is you have said in your inquiry statement that any risk to private water supplies is too great, implication being presumably the application should be refused. Is that your position?
Yes.
Yes.
Right, I think I get you now. Okay.
Okay.
Right. The risk is too great. If the risk cannot be mitigated out, and I don't mean mitigated by, for example, booms for removal of oil from certain waters that we were talking about just prior to the break. If the risk is too great and we don't have enough evidence to prove that the risk will not harm or cause problems with the private water supplies, then we would object to it as an environmental health service.
Understood.
Okay.
And I suppose then, in terms of the reporters' roles here, what the reporters are looking at is the evidence that's been presented and trying to understand whether on the basis of that evidence, the risk is too great or not.
Okay.
So it's not the case that any risk is too great. It's a question of the level of risk and reaching a balanced judgment based on that. Would you accept?
I would accept that to a point. It's not just the level of risk, it's the type of risk. And as I have stated before to other peoples and other companies, we do not hold a stance that we are against wind farms. That is just not correct. However, if we look at a wind farm application, or in this point, an extension application, and it's deemed there's too much risk and not enough evidence to prove that risk will not have a detrimental effect on water for human consumption, then we would ask that certain points are either removed or proof is given that they will not harm in the future. Now, if that means the removal of turbines, certain turbines, the removal of borrow pits, or not going ahead with certain construction things such as trenches going in a certain area, maybe looking at alternatives that wouldn't have detrimental effect on drinking water for human consumption, then that's what that mitigation would have to be. And if it's the removal completely of turbines and borrow pits, as has happened in the past, then that's what it has to be.
Yeah. Okay. I think I understand your position slightly better now. During your examination in chief, and just touching on that point about removal of aspects of the development, you talked about the two access roads. You talked about the Arnameen one, and then also the access road to the north. You remember that?
Bents.
Yes. Now, I think I have you noted correctly as saying that you hadn't personally visited that access road. Is that correct?
No. I visited the access road. I was questioned on the farm and what Bent's farm was used for. I haven't personally visited Bent's farm to see whether the stock is beef stock, hill stock, or if it's dairy farm, arable, or what. I don't know what they do at Bent's. Kilrenny I've spoken to, and I know the road going in as far as it goes as far as the underpass at the railway.
Yeah.
As Tarmac
My
Road.
apologies, I picked you up incorrectly on that. But I certainly had you correctly noted as saying that you didn't know what type of traffic was going to be used on that road or what was proposed on the road.
I'm not sure about what type of traffic. I think from memory, it was left, it wasn't a closed subject. However, it's purported to be HGV lorries and various other vehicles like the four-wheel drives and the other wind farm traffic. Is that correct? As far
No,
as I'm aware, that's I'm of the opinion of. But if larger vehicles and larger loads were required to use that as an access road, for example, the larger vehicles that take in the components for the actual turbines themselves, it would be a major construction issue, a construction site. It would be a major change to that particular road, to the roads there, the access roads,
Yes.
and to the access below the railway.
Well, cutting to the chase, are you aware whether any works are proposed at that road as part of this application?
Only what's in the EIAR, and
does that show any proposed works?
It did mention Bents and the access road. I don't have it in front of me, but it did say
Did it propose the sort of major construction works that you were discussing just a moment ago?
There was nothing mentioned of that, but from memory, from what I can remember, it didn't say there wouldn't be, which was a crucial factor.
Well, are you familiar with the way that that applications and consents work? Generally, someone can only do what they have consent for. So if they haven't applied for consent to undertake major upgrades to the road, generally speaking, they can't do it. Would you accept that?
I would accept that.
Okay.
Unless they apply later for a change.
And that's a matter that would have to be assessed if they applied for that change at that
Separately.
stage.
Yeah, separately.
But the applicant has not in this case.
Okay. Okay, accept that.
Okay. In your precognition, and Mr. Campbell has covered some of the ground that I wanted to have a look at next, but in your precognition, you said that you disagree with all of Mr. Robb's 11 conclusions in his inquiry report. And I wanted to have a look at the inquiry report with you, please.
Okay.
It's page, it's document CD 15.15. And it's page 24.
Okay. The conclusions? Is that
Yes.
correct? Ian? Yes.
Now these are, just to be clear, it's the 11 paragraphs in section 8 that you say you disagree with.
Yes.
So, starting with 8.1, first sentence, Mr. Robb says that his assessment work has been completed in accordance with industry standard best practice. You don't have any qualifications in hydrology, hydrogeology, geology, or soils, as you very fairly say in your precognition.
That's correct.
What evidence have you presented that Mr. Robb has not completed the EIA report in accordance with industry best practice?
The detailed desk studies, I don't believe there's enough evidence presented. So is it in the best presented with a detailed desk study and not covered in site visits?
But my question really is...
Standard best practice. Don't believe there's enough evidence being presented.
Well, let me put it a slightly different way. Is there any guidance relevant to risk assessment in this process that Mr. Robb has not followed?
I don't know, I wasn't with Mr. Robb.
Well, you've read what he said in his environmental impact assessment report and the PWSRA.
Mm-hmm.
Having read that, is there anything that you say, any relevant industry guidance that he has not followed?
The guidance that we would follow would be the DWQR risk assessment. Technical manual is what we follow and go through.
That's what...
Has that been applied? I don't think it has, because I don't believe he's visited all of the owners. I don't believe site visits have been carried out to each and every property, but not only the property, to the catchment areas and to the source collection points, which is stated you should do with the owners present.
Is it your evidence? Sorry to cut in there, but just one question that's relevant to this point. Is it your evidence that the risk assessments Mr. Robb had to do for this process are the same risk assessments that you as a local authority must do by reference to DWQR?
I would have thought they would need to be more thorough, because we are doing them, we follow the DWQR risk assessments to do with the water supplies and human health, as Mr. Robb will have had to do as well. However, we're not bringing that on the back of that. We're not bringing in major change to the area. We're not proposing construction or development of any kind. And I think that's the critical factor in this, is the risk assessment being done by Mr. Robb or others such as Mr. Robb for proposals that have the potential for huge change, and not just change to the ground and to the area, but to the livelihoods and to human health of people in the rural areas, of certain properties, not all areas. I won't say a blanket, but certain properties and certain.
That really, it comes to the nub of the issue, I suppose. Where in the drinking water quality regulations, or the guidance, where in the guidance does it suggest that the risk assessment process should be applied at the stage of an application for planning permission or for energy consent?
I don't think it does, but anyone who has any kind of duty of care, which is mentioned in the regulations and in the legislations, anyone who is going to take on that responsibility of duty of care has a duty of care to do a risk assessment. They also have a duty of care not to harm or pollute.
Yes, but if we come back to what the environmental impact assessment report did, it adopted a source pathway receptor assessment process, which is what the council required it to do, didn't it?
Did it? Has it?
Sorry, when you say did it, do you mean
Did it? Has it?
did the EIA report follow that approach, or did the council ask for that approach to be
I
followed?
think it does in part, but it doesn't in full. I don't think, but that's my own personal opinion.
Okay, well let's start at the end of that. Did the council ask for a risk assessment process based on source pathway receptor to be followed?
No, they asked
No.
for a full hydrological, hydrogeological risk assessment site-based.
Let's have a look at the
think
EIA report.
I don't have that, Ewan, I don't have that online, so I've got hard copies, I'm afraid they're big.
That's fine. I've got a hard copy as well. So it's document CD 1.2, and we'll just give everybody a moment or two just to look that up.
Can you give me the title of the document, and so I can?
Yeah, certainly. So it's the environmental impact assessment report, and it's chapter 10 that you're looking for. I'm just checking, have the reporters got access to that document now? Yes, okay, thank you. So if you go to page 10.6, you will see the response from South Ayrshire Council. In the third paragraph down, the applicant shall submit to the Planning Authority a site-specific hydrogeological report which contains a review of the risks to all private water sources and supplies that have the potential to be affected by the development. And what the applicant says in response to that in the next column, hydrogeological and hydrological site setting discussed in section 10.3 and private water supply risk assessment presented as technical appendix 10.3. So they have followed the guidance that you, the council, asked them to follow.
Excuse me, could you just give me the paragraph reference again?
Certainly, yes. It's page 10.6 or 10-6, and it's a table which sets out the various. It's just after paragraph 10.2.7, consultation. So then, question for Ms. Loban, I suppose, going back to the point about the drinking water quality regulator. There is nothing in here that suggests an assessment in line with the assessments the council would undertake under the DWQR guidance, is there?
Not in that particular tract there, no.
Or not in anything that the council said in response to the application? Okay. If we return then to Mr. Robb's inquiry report and his conclusions. So that's CD 1515 for anyone who's put it away. Paragraph 8.1, the second sentence, Mr. Robb says, detailed desk studies have been validated by site surveys, have informed the site design so that many of the potential impacts associated with construction and operation of the proposed development are avoided. Do you disagree? Do you disagree with his conclusions that the site design has been informed by detailed desk studies and validated by a site survey? You're on mute at the moment, I'm afraid.
Sorry, Ewan. Which document are we reading off here?
We're back to Mr. Robb's inquiry statement, please.
Inquiry statement.
So that's CD 15.15.
Is that number 8 conclusions we're talking about?
It is, that's right. It's page 24.
And which number is it? 8 point?
We're still on 8.1, I'm afraid.
Okay.
So
right.
what I was saying is 8.1, the second sentence, about halfway down 8.1, Mr. Robb is essentially saying that the site design was informed by detailed desk studies and validated by site surveys. Do you disagree with what he has said there?
I don't disagree with it, no, but detailed desk studies do appear to have made up the main of the risk assessment from what I can read in the hard copies that I have on my desk.
Yeah.
That I have read through.
Okay. Well, Mr. Campbell.
But no, I don't agree. I don't disagree with it, Ewan. So sorry.
You don't disagree with it?
I don't disagree with it, no.
So you agree with it then?
I'm agreeing with it, yes, but with a big but.
Good. Excellent. Right. So 8.2, Mr. Robb says it's been shown that the footprint of the proposed development is very small compared to the geological and hydrogeological units that lie beneath and adjacent to the site. Now, I heard your evidence in chief, and that's maybe clarified things. So to cut to the chase, as I understand it, you don't disagree with that. Your point is that the size of the development relative to the underlying hydrogeological features of the site is not the important thing. Is that your point?
The size of the development and the cumulative effects of other developments in the area.
Yeah. Okay. So in essence, we're really back to the question of, is the risk assessment relevant? So you don't, again, you don't disagree with what Mr. Robb has said about the underlying geology or hydrogeology of the site?
I can't disagree with it. I'm not a hydrogeologist. I'm not a hydrologist. However,
Fine.
However, the size of the development, it does say that showing the footprint of the proposed development is very small, and I don't know how you can come to that conclusion. In comparison.
Well, it's a matter of fact, sorry to cut in, but it's really a matter of fact, isn't it? I mean, the question of what significance you take from it's another matter. It's a matter of fact as to the scale of the development and the scale of the underlying hydrogeological features.
I don't know if I would agree on that. I don't know if I could agree on that. I don't know how I could agree on that.
Well, what else could it be?
Well, the size of the development, how can you compare that to catchment areas? How can it be compared? Footprint.
You simply take the size of the development and you take the size of the underlying catchment areas and you compare
It's
them.
not just the size of the development, however. It's not just the development and in one word that we're looking at here, though. The footprint is not just going to come from development. There's before the development happens. You've got the forestry. In fact, it's going to be a restructure. It's not just going to be taken out in coops. It's going to be a full restructure of the forestry. We're going to need access for vehicles which are all diesel fueled and diesel powered. The size of the development of that, and then the size of the development of the Arecleoch extension itself, and the traffic and everything else involved, absolutely everything involved with that. And then after that extension has been built and is up and running, should it be up and running, then there's the ongoing maintenance and it's in perpetuity or for all times, I believe, in which case the upgrades at later dates. And on top of that, the cumulative effect. This is the crucial part here. It's the cumulative effect, because the access road from Alneymean Bridge is not just proposed to be used by Arecleoch Extension, as I believe. Marie have gained access or to do the Chimmery. It's a cumulative effect here.
I wonder if I could just come in a moment. We seem to be at cross purposes a little bit, and it might be the use of the word footprint and perhaps Mr. MacLeod using it in a physical sense, and you were, Ms. Loban, thinking about it in terms of the footprint of effects. But in any event, I think I understand your point that the comparison in terms of the effects of the development, the comparison, which is the important one, is not the overall square meterage of the footprint. It's wider than that, and if that's all it is, then perhaps we can move on.
Okay, sorry, Ewan.
No, that wasn't necessarily aimed at you. It was also aimed at Mr. MacLeod.
That's fine. There are 2 points that flow from it, though. One of which is, although you say that the size of the development footprint is not the only thing that's important, and I would accept that, but the size is important when one comes to considering the extent of risk. So, for example, let me give you an example. If development was taking place right across the entire catchment area, that, on the face of it, might be perceived to be more risky than certain limited elements of infrastructure within the overall catchment area. Would you accept that?
I would accept that.
Okay. And then the second point, which comes from your answer, is that do you accept Mr. Robb believes he has assessed all relevant cumulative effects and all aspects of the development?
Do I believe he has? I don't know. I can't speak for Mr. Robb. I can only speak for
That's
Mr.
fine. We'll let Mr. Robb speak for himself in due course. So, returning then to his conclusions, we've touched on the first sentence in 8.2. The second sentence, Mr. Robb says, it's also been shown that the geological units beneath the site have a low bulk permeability and do not readily store or transmit large quantities of groundwater. I take it you accept that. This goes back to your point about not being qualified in this area, but you accept, you don't put any counter evidence forward to Mr. Robb's professional view on that matter.
I can't put counter evidence forward because I don't have the qualification to do so. It would be wrong for me to do so unqualified. However, I have to make decisions based on my own knowledge, based on my seniors' knowledge, my team coordinators' knowledge, and the knowledge of the people out on in who live in the areas. Now it says it has been shown the geological units beneath the site have a low bulk permeability and do not readily store or transmit large quantities of groundwater. But what is that based on? Is that based on a desk study, or is that based on a day's site visit, or what's that based on? We don't have enough evidence.
Well, let's leave it to Mr. Robb to explain what he meant by that statement.
I think the question here, Ewan, is that we don't have enough evidence.
We don't have enough evidence on that issue of low bulk permeability.
That's one of the issues we don't have enough evidence on.
But you're not qualified to assess it even if you did have that evidence?
I'm not, no. But it doesn't mean to say we couldn't get somebody who was qualified to do so.
Well, let's be blunt about this. You shouldn't be coming to this inquiry suggesting that someone else might have assessed the evidence differently and might come to a different conclusion. If the council has a position on Mr. Robb's evidence, it should be in front of this inquiry now. Do you understand that?
Yes,
So the second part of 8.2.
Can I just come back on that? So that point, I think that's a very important point you just raised there. A very important point there. It's not that I'm bringing or suggesting that we would bring anyone in at this point in stage of the inquiry, but you did say to me, do I think? And I'm saying, no, I don't think. I can't make a decision. There's not enough evidence there. And when you said, well, I shouldn't be bringing, or we, the council, shouldn't be bringing anyone in at a later stage, the only way I could do that, I could personally do that, would be to get someone else to make that decision for me. And if that was necessary, we would do it, we could do it, but you're the person who brought up the point. I think Mr. Robb needs to speak on that point. I don't.
Well, with respect, I'm not the person who brought up the point. You're the person who brought up the point in your precognition, because you said you disagreed with all 11 of Mr. Robb's conclusions. And what I'm doing, in a fairly laboured way, I'm sorry to say, is going through those conclusions to understand whether you truly disagree with them, and if so, whether you've got any professional or factual basis for doing so.
Well, I don't have any professional basis to do so, but we do need proof that the development won't cause any problems, and I don't think enough evidence has been shown. And to come away with a statement such as the low bulk permeability do not readily store water and transmit large quantities of groundwater may be factual, but it doesn't mean to say that it cannot be harmed in the future. That's a statement on its own.
Yes, but without really wishing to state the obvious, risk is a factor of geology and hydrogeology when it comes to private water supplies, isn't it?
It is.
And in order to properly understand levels of risk, you need to have a sound understanding of what the hydrogeology is, don't you?
Depending on what you're looking at, yes.
Well, not depending on what you're looking at, the answer is simply yes. Yes.
Well,
and you don't have that, do you? Despite I accept the fact you've got a lot of practical experience on the ground, but you do not have that knowledge and professional experience, do you?
I don't know. I don't have the qualification. No.
Thank you. Okay. So far as 8.2 is concerned, Mr. Robb has talked about some evidence that he says demonstrates what he's just stated. You've not presented any evidence to counter that, have you?
No.
8.3, I think, really, take your time to read it if you need to, but I think 8.3 really follows on from 8.2.
Sorry, am I?
Sorry, I was really, my question was maybe it wasn't put as a proper question. 8.3 is really just following on from 8.2. It's really saying the same thing as I understand it. Would you accept that?
This is one we've looked at internally, and it's been confirmed that excavations to establish the turbine foundations and the borer pits are unlikely to intercept significant quantities of groundwater. Unlikely is totally different to not intercepting. It's not concrete, for want of a better expression.
Thankfully, there's no concrete involved in this.
It just dawned on me when I was about to say that. I thought, oh dear, no, talk about puns. And it's also stated that it's noted there's limited dewatering associated with turbine foundations as temporary. Is that true? It might be true in some areas, might not be true in other areas. I have difficulty with this particular evidence, shall we say.
But I think my point was that really comes back to, if you go back to 8.2, you will see that Mr. Robb says that observations during construction of the turbine foundations at Arecleoch and the neighbouring Kilgalleach wind farms, which were developed within a similar geological setting, required little temporary groundwater management. So that's the basis of his statement there. And you've not presented any evidence to counter that.
No. That's correct, the statement above. However, this is an extension. Now, we're looking at Arecleoch, and Mr. Robb states that the foundations at Arecleoch and neighbouring Kilgalleach, and they are not in the vicinity of the areas that the private supplies that we're looking at present, now, in this point in time.
The point, sorry to cut in though, because the point is not so much to do with the proximity to the private water supplies, it's to do with the characteristics of the geology and the likelihood that significant dewatering could occur.
I agree. I mean, I agree it's to do with the characteristics and the likelihood. However, as I stated, Arecleoch is up and running, as Mr. Robb quite rightly says, and Kilgalleach, as he quite rightly says. However, this is an extension, this is new. This is not, this is going to, we're looking at cumulative effects here, but we're also looking at introduction of development into areas that are not developed at the present time. So to say that limited dewatering is happening or no dewatering is happening might be true statement. However, this is a new development. So the long-term alteration of groundwater flow paths or levels as no long-term groundwater control is required to maintain the wind farm infrastructure. Again, it's a new development, it's new. We need proof that it won't. Well, because it could have catastrophic effects if it should happen. If problems were to occur in dewatering or the alteration of water courses and private water supplies were to realise a decrease, whether significant or otherwise, of their water. We're talking solely about dewatering at the present point in time, coupled with the changes that are now being noted, and most especially in the past 3 years of climate change, then we could end up with serious problems for householders. And it is our point of view that should problems occur in the future, it doesn't necessarily have to happen at the developmental stage, it can happen afterwards as well, because we're talking long term here, we're not talking just the development stage. It's our opinion of environmental health, not just my personal opinion, it's the opinion of environmental health, that bowsered water or similar is not a suitable alternative water supply. So with that in mind, certainty, we need certainty that this is not going to permanently disrupt the flow of water.
Yes, but I think with respect, you're conflating quite a number of different points in that, and I suppose at this stage, all that we're looking at is the underlying hydrogeology and the evidence that exists at the moment as to what effects works at the borrow pits, in particular, Mr. Rob has referred to here, what effects the works at the borrow pits are likely to have.
Okay.
That's all that we've really been looking at this point in time.
Right. Well, with regard to the borrow pits as well, we had a request to sample water at one of the properties, which you'll be well aware of because it's submitted in the evidence. Due to blasting at borrow pit 2, now this might not be the borrow pit we're necessarily looking at in this point in time, but he reckoned it was either borrow pit 2 or 3. He reckoned it was borrow pit 2 and looked at maps. There's not enough evidence, there's not enough proof, and dewatering could happen because if you're extending quarries that are already there or borrow pits that are already there, the potential to alter flow of water is there. It's a reality. I think everybody's aware of that, regardless of what the hydrogeological makeup of the ground is. The reality is the potential is there. Now,
Okay. I think we've probably taken that.
It's not just the potential, it's the proof, the evidence. We need proof that it won't alter the flow.
Yeah, we've probably taken that, but as far as is likely to be useful for the reporters, I think, and Mr. Rob can come back and cover it again if required. But just one point about the previous impact. You talked about the blasting and so on. Do you accept Mr. Rob's evidence that whatever may have happened, it did not happen during the construction of the Arecleoch wind farm? It was not the applicants who were responsible for that blasting operation?
No, I don't accept that. I don't know. I wasn't the officer who went out. However, the owner of the property is quite adamant it was during the construction of the Arecleoch wind farm. And as far as I'm aware, the borrow pits were used during the construction for the construction of Arecleoch wind farm.
Yes, the borrow pits were used for the construction of the Arecleoch wind farm. But Mr. Rob's evidence is that the blasting events that you describe in your evidence happened after Arecleoch was completed.
Sorry?
Let me put it a different way. When did the blasting events that you describe, when did they occur?
I haven't got it in front of me just now. I haven't got that. Might be in my report actually. I would need to come back to on that one because I don't actually have that in front of me at this point in time.
Could you just 1 second, I'll see if I can help.
Hold on. Just 2 seconds, if you would, please. In 2016, I believe it says here. It's in my own outline report, paragraph 19. I've got it written down.
Yeah, I think I can see it in your inquiry statement in paragraph 19 as well. That helps.
Thanks. Apologies, you found it before me. So, Mr. Robb's evidence in his inquiry report, so this is page 17. He says at the foot of page 17, Mr. Robb says the borrow pits were not used in 2016 in support of construction. Sorry, I hear somebody scrolling. I just make sure you've all got that.
Sorry, it's me.
It's you.
sorry about that.
No, not at all. Not at all. So it's page 17 in paragraph 7.6. And the very last bullet point, he says the borrow pits were not used in 2016 in support of construction of Arecleoch or Kilgalleoch wind farms, and therefore the reported impairment of the borehole from the borrow pits cannot be attributed to wind farm construction activity. That's a statement of fact, and you've not presented any factual evidence that that is incorrect, have you?
No, but I did read in the very large documents, which you can see here. It does state that the borrow pits were previously used for Arecleoch construction and for...
Yes, there's no dispute. There is no dispute that the borrow pits were used or that borrow pits were used previously. The point is the events that you describe occurred at a time when the applicant was not using those borrow pits, and you've not presented any evidence that that statement is incorrect.
Well, no, that's correct. I haven't presented any evidence that's incorrect. However, I have to go in the word of the owner, who quite categorically stated when there was blasting in the borrow pits, there was problems with the water. As I said, I wasn't the officer who attended at that point in time.
Yeah. Okay. Let's go back to the conclusions then. And I think 8.4 you touched on in your examination in chief with Mr. Campbell, so I think I understand your position on some of that. But just looking at what Mr. Robb has said, the surface water catchments at site have been subject to much previous modification, which has included the development of an extensive track network and artificial drainage to improve forest yields. You accept that, presumably?
Whose report are we reading now? Sorry.
We're still on Mr. Robb's inquiry statement, I think it's described as.
8 point, sorry.
8.4.
Okay.
Just a point of detail, Ewan, it's called an inquiry report.
Right.
I'm sorry, I'm
Um,
I'm not up on the speak.
have you got that now?
Yes, I have. Sorry.
Yeah, okay. So 8.4, first sentence, the surface water catchments at site have been subject to much previous modification, which has included the development of an extensive track network and artificial drainage to improve forest yields. You don't take issue with that statement, presumably?
No, that's correct, it has.
The proposed Arecleoch wind farm extension makes use where possible of these existing tracks so as to limit the extent of new track construction. You accept that?
No, I don't accept that because there will have to be introduction of new access tracks.
It's not what it says. It says the proposed Arecleoch wind farm extension makes use where possible of these existing tracks so as to limit the extent of new track construction. Do you
Okay, I would
accept
have
that
to-
as
I would
part
have
of the
to- I would
design of
have
the
to
wind
accept.
farm? You accept as part of the design of the wind farm, the applicants have endeavoured to use existing access tracks to minimise impact.
I would have to agree that the make use where possible of the existing tracks, but the fact is new development happening will mean there will have to be new access tracks and new water crossings, etc. introduced. So yes, I do accept what's stated there for that point, that it makes use where possible. What it doesn't state is how much is going to be used and how much new will be introduced, how much new areas will have to be introduced.
Well, we'll not take up time with it just now, but I think we can go back in due course and have a look at the environmental impact assessment report, because there will be a description of new access tracks and existing access tracks used.
Okay.
But focusing on one part of the existing track network in particular, you talked about the Arnameen property during your examination in chief. Do you accept that there are no proposals to upgrade or do works to the existing access track as it passes the private water supply source at the Arnameen property?
Is that written?
Well, it's not written, that's the point. There are no proposals to upgrade tracks.
Okay, well, if you say there's no proposals,
Well,
but if it's not written, then
let me put it to you a different way. Did you, when you were talking about risk to Arnameen, did you assume that works would be taking place to the existing track network in the vicinity of the PWS?
the assumption, no, didn't assume anything. The fact that there's going to be heavy traffic moving there, but not just one wind farm, there is the possibility of the cumulative effects from Germany now. I should actually say the cumulative effects of Arecleoch extension on top of the Germany application, using that access road, access route in.
There are no proposals, but to be clear, there are no proposals as part of this application to do any work to that existing access track, are there?
If you say so, if it's not written down, then I have to accept that. And
in your evidence, you talked about, sorry, just give me 1 second. You suggested that access roads would need to be renewed given the level of traffic. Is that,
Mr. MacLeod, I wonder if I could just ask a question here. Just it may be that you're going to move on from Arnameen, but or you might have covered it, but it's just a question that occurs to me. Ms. Lobban, you've expressed concerns about the effects on Arnameen, and what I want to know is whether those are based on just the effects of additional traffic, or whether it was based on an understanding that there was going to be physical construction works near the private water supply, or are you not sure which? I think it's just important that we know what it is your concerns are about Arnameen.
the concerns over Arnameen experienced problems during the construction of Arecleoch, and that was reported, but the owners didn't want anything done at that point in time, so they couldn't act. The concerns I have over Arnameen being the main entrance, the water supply, the catchment area, from what I can gather, from what I can see in my risk assessment, is very close to a road that will be used by heavy vehicles and heavy traffic again. the cumulative effects, the possibility, the potential of cumulative effects should Chimney also use that. Upgrading of the road, upgrading of water course crossings, I don't know, will they need to be looked at, will they need to be renewed, will work need to be done in that area? The water supply is also downgrading of a large stacking area as well, so forestry has the potential to have effect on the catchment area there and the runoff. My concerns are, I can only speak to private water supply obviously, but quite a number of concerns over the amount, the volume, it's how to put this, the volume of traffic that will be there for the developmental stage, but also before development stage for the forestry, and after the development stage. I know we're talking about this application, but we have to look at it as a whole. And although I think the owners described their water supply as a well, there are new people in, again, it's a seep well, it's a sump into the ground, which is collecting water, which is from round about in the boggy areas. And I have personally seen, when I visited that property before, the owners, the present owners were there in extremely heavy weather, extremely heavy rain. The water does rise up around the property, the water flows down and rises up around the property, and the property appears to be built on a sort of, again, I'm not an expert and I'm not qualified to say, but some kind of hard area, and it's probably been chosen to build on because of the base it's on. I've seen the water rising up round about the property, and then once the really heavy weather, the really heavy rain disappears, it can disappear in 2 or 3 hours. So that, to me, raises concern for the private water supply with the access road being used potentially as it will, and for the stacking and moving of other goods and things there as well. I'm not sure if I'm being clear. If I'm not being clear, say to me and I'll try and put it in a different way. Does that answer your question?
No, that's fine. That's helpful. I understand what, yeah, I understand what you're saying about, or I understand your concerns. Can you hear me? Just put your hand up, just make sure you can hear me.
Yes.
Yeah. About additional traffic and the possible consequences of that. And you mentioned forestry and the laydown area, but I'll just tell you our understanding of what's proposed there. And if you look at your map, CD 16.8, and if you look at the access track as it passes, or start of the access track as it passes Arnhem and heads southwest.
Yes.
You see that, and the access track is black.
That's correct.
So our understanding is that all the access tracks in black are not to be upgraded at all. They'll be reused as is. And there are different colours of green for upgraded tracks, for new areas of track, and indeed for upgraded water crossings. So I just want, and so the water crossings on that track are also not to be upgraded. So I just want to be clear, so as I understand your position, is that even if that's the case, and there's no physical works along the entirety of that track, you still have concerns about the effects because of the additional traffic in the forestry. And that's fine if it is, but it's just I wasn't clear from what you said in your written submissions, whether you understood that there wasn't going to be any physical works there.
Right. No, I understand there's not proposed physical works on that section of track, but I do still have serious concerns regarding the traffic, regarding the water crossings. and the water and the way the water is taken for Arnhem and the business that Arnhem are running now. So with tourism and people coming in, I have serious concern.
Okay, that's absolutely fine. Thanks. It was just a point of clarification. My apologies, Mr. Cloud. I'll go back to you.
No, not at all. So that's helpful. And
Sorry, Mr. McLeod, before you say, I'm just thinking about when's a good time to stop for lunch. Obviously, Miss Lobin's been answering questions for an hour now. Do you have a natural point coming up where it would be useful to stop, or how are you feeling, Miss Lobin? Do you want?
I'm okay with whatever Mr. McLeod wants.
I mean, I'm kind of in your hands, ma'am. I mean, my intention, as you'll probably have worked out by now, my intention is to go through the conclusions that Ms. Lobin says she disagrees with. So, you know,
So we're potentially a wee bit to go. If we're just saying we're on 8.4 now. Have you other questions to ask on 8.4?
No, we're done with 8.4.
Right. Well, we maybe stop for a break now and reconvene on 8.5.
Yeah, that's fine.
That'd be okay. If we say 20 past 1, would that just 45 minutes enough, or is anybody needing the hour? Okay, so if we reconvene at 20 past 1, and we'll pick up at with your questions on the conclusions in Mr. Robb's inquiry report. Okay, if you switch off your video and your sound. I think we're going to be in on Friday. Yeah. Thank you, Amir. I've got to go and give blood on.
Are your microphone still on, ma'am?
Okay, I think that's everybody. Everybody back. Good afternoon. Ready to get started again on the afternoon session. So back over to you, Mr. MacLeod, for your questioning of Miss Lobban.
Thank you, ma'am. Afternoon, Ms. Lobban. So really just picking up where we left off, I was asking you some questions about the conclusions in the inquiry report, and the reason for that is that your precognition says you disagree with all of the conclusions. So I'm really just trying to explore the extent to which there is scope for agreement and where the disagreement really lies. Have you got the conclusions section available? It's section 8 on page 24. Yeah, you're still on mute at the moment, I think.
Sorry, yes, I do.
That's okay, thanks. And we'd reached 8.5, and in essence, as I understand it, what Mr. Robb is saying in 8.5 is a source pathway receptor model has been adopted using evidence that was held by you and by other data sources which he's verified on site. Now, I accept that you don't think he's done enough, but do you accept that he has followed the approach he's described there?
It states that in addition to characterising the private water supply sources, the potential pathways to these between the development and each private water source has been considered to complete the risk assessment. And I don't think there's enough evidence in that there either. There's not enough clarity around what's been taken as the source. Is the source actually the catchment, which is the source? Or is the source, it does mention on at least, I think it was the Arecleoch visit, they did a site visit, I think they went to 1 or 2 properties in that site visit, and they talk about going to the collection tanks at the source, where the source uptake is, but that's not the source. The sources are the catchment areas. So I don't think there's enough evidence been given there. Okay,
so you've got particular concerns about that one, and no doubt Mr. Campbell can ask Mr. Robb about what he considered there. But your concern is to do with the source as opposed to the pathway. Is that right?
Not as opposed to, no, alongside, it all runs in tandem. Something happened there. Sorry, something happened in the screen.
I was distracted as well.
Sorry, to answer your question, Ms. MacLeod, no, I would see that the sources, the catchment areas being the sources. Now, catchment areas can be huge or they can be a very small area. And I would say they run in tandem to the potential pathways, the pathways and the receptors. The information in that particular paragraph 8.5.
Right. Well, again, perhaps just to cut through this, we can leave Mr. Campbell to ask Mr. Robb questions of the approach that he's taken if he's got particular concerns. And we can just move on to 8.6. Let's start at the end of that. So Mr. Robb says that various statutory consultees have reviewed the assessment completed and haven't objected to the proposals, the assessment or the methodology used to complete the assessment. So that's correct as a matter of fact, isn't it?
The statutory consultees being including SEPA, Marine Scotland and Nature Scotland have reviewed it and have not objected to the proposals. Probably correct, yes. I would agree with that, but it's South Ayrshire Council who enforce the private water supply legislation.
Yes, and we'll come to that legislation in due course, have no fear. But at the beginning of 8.6, Mr. Robb says, over and above the embedded mitigation afforded by the site design, mitigation measures have been proposed in the EIAR to protect ground and surface water resources, including quality flows and yield, and to ensure the quality interests of the water-dependent habitat and WFD clarifications are not impaired. That is correct as well, isn't it? He has proposed specific mitigation, and there is mitigation through the conditions, which we'll come on to shortly, that will protect against impact.
I agree to the fact that he has proposed mitigation measures and they will protect to a certain extent, but we don't have full faith that they'll protect completely. We just do not see there's enough evidence given in protection and in the robustness of that type of mitigation, and whether or not mitigation should be being used as opposed to removal of certain parts of the development instead of mitigation. I don't know if you're wanting examples in that at this point, not, but I can give examples if you want.
Well, Mr. Robb's evidence, I think, is that mitigation is embedded in the design. The design has been influenced by the risk assessment process that he has undertaken to in effect, minimise the risk that the development might have on private water supplies. You accept that?
I accept that, yes.
And that to avoid any risk or any further risk from the built development that remains as part of that process, a series of conditions are proposed that would ensure effective mitigation. You accept that approach?
So the series of conditions being?
Well, let's go to them. We were certainly going to get to them in the course.
For example,
let's go to them now. So it's document CD 24.2, and this is the document which is called Comments on Questions Regarding Draft Conditions.
Can you, sorry, Mr. McLeod, can you tell me what that is? Because I don't have I've got it in a different format.
Sure. It should have been on the list that was circulated yesterday. So it's document CD 24.2, and it will be on the hub if you've got access to the hub.
No, I don't seem to have it.
Connor's got it down.
Yeah. I think because the document came in after the 31st, I don't think it's on the memory sticks, but certainly it was circulated to parties. It just may not have been forwarded on to Miss Lobban. Mr. Campbell should have it, but
should have it, but I don't. But it's somewhere on my screen. But it's probably
for the purposes of my questions. Sorry, I was just going to say, sorry, John, to interrupt, but for the purpose of my questions, we can use any version of the conditions, I think.
Absolutely fine. I just wanted to, say on behalf of the council that this witness has not to do with the drafting of it. But of course you can ask.
Let me just see then if there's another document that has the list of conditions.
24.1 is the previous iteration.
Yeah, 24.1.
Sir, thank you. That would do, yeah.
Which page, please?
We'll get to that.
I just want to check, Ms. Logan, do you have access to 24.1, which is called Draft Proposed Conditions?
No, I don't have it. I'm looking for it, but I don't see it. 24.1, I don't know.
One I think should be on the hub. That one I think should be on the hub.
I wouldn't know how to go into the hub. Somebody will need to tell me how to access.
Is it possible that someone could email this to you, Robin, and we can maybe return to it later on? I don't know if that would work for you, Mr. McLeod. But just
I can certainly do that. I can certainly do that, sir. But McLeod would tell us which page he wants to talk about, I can send it to, sorry, I may be taking the legs from under your question, but if you can tell me which page you want to make use of, I can send it to Miss Block.
There are a number of pages that I want to refer to, so it'll be the full document that needs to be sent. But yeah, I'm happy to park that just now, and we can come back to it once Mr. Campbell sent the document through to Miss Loban, and we can just check that she's got that. Okay, so I think we'd probably covered 8.7. We may come back to that one once you've got the conditions, just to kind of put it in context. So on to 8.8, we're nearly done with this chapter, in peace sake. So 8.8, Mr. Robb says the inquiry report presents detailed evidence on two key matters related to whether the information in the EIAR and this report can be used to inform an appropriate determination, and the likely effects of the proposed wind farm. So although you may disagree with the extent of the evidence, the report, etc., does provide evidence, doesn't it?
Our opinion is there's not enough information or the type of evidence that we require. It's presenting some information and some evidence, but we're opinion that it's not enough to prove that it won't have a detrimental effect on the sources
Yes.
of the catchment areas.
Okay. Now, excuse me, 8.9a, don't present any evidence to dispute the conclusion the undertaking's been presented in accordance with best practice. I think we discussed that earlier on, and you talked about the drinking water quality regulator. But there's nothing else that you're pointing towards that says that Mr. Robb should have done the assessment in a different way.
No. I agree with
Your
that.
outline
But it goes on in the same sentence to state, and it contains sufficient information to allow the application to be determined, and disagree with that. Where the opinion is not sufficient evidence, sufficient information to allow a determined decision.
Yeah. Now, your position, and I think you repeated it again in evidence in chief this morning, is that a number of properties hadn't been assessed. You've read Mr. Robb's inquiry report clearly and have seen what he says in paragraph 7.6 and table 7.3.
Oh, I've lost you. Hold on a second. I've lost the screen.
Okay, I'll give you a moment just to get that back.
Right, sorry, what I clicked on there, but I clicked on something that blanked everything out. Right, sorry. Could you repeat that?
No problem. So yes, you've made the allegation that there are a number of properties that weren't considered, and Mr. Robb has responded to that in paragraph 7.6, which is on page 17 of his inquiry report.
Is that the tables?
Yeah. So what he says is, SAC provide details of properties with PWS sources reportedly missing from the EIAR and the risk assessment, and which have potential to be affected. These are considered in table 7.3, and using the same methodology and assessment of potential linkage has been completed. Now, you've not said anything in your recognition about what's said in those tables. Do you accept, presumably, what he has said now regarding risk?
No. If
Well,
the
that's-
blasting was, well, for example, the first one there, the evidence there, if Wood Park Farm, if the blasting was undertaken by other parties at Borough Pits 2 and 3 in 2016, it's not known what controls were in place. If it's not known what controls were in place, and it is true enough that it hasn't been used by Arecleoch, which I'm led to believe it was used by Arecleoch. However, if it's not known what controls were taken in place, then how could you go in and search for an extension to the Borough Pits in safety? There's not enough evidence given to prove that it won't damage the private water supplies, the sources, the catchment areas, for example.
What Mr. Robb goes on to do is, in that table, is to indicate that he's provided cross sections for the inquiry that demonstrate that it is very unlikely that there is hydraulic connectivity between the Borough Pits and the receptors. You've not challenged that evidence.
No, but as I said, if Mr. Robb says it's very unlikely, where is the evidence of this? What is he basing this on? There's not enough.
Well, he's basing it on his professional opinion and years of experience in construction of wind farms. What are you basing your answers on?
On guidance of people such as Mr. Robb and others who are professionally qualified. Basically.
Which professionally qualified individuals have you taken opinion from in relation to what's set out in table 7.3?
I haven't taken any professional opinion from anybody as per table 7.3, whatever it is. What I'm saying is, I am not professionally qualified, as I have stated time and time again. We look at it, we risk assessment criteria, we try and do the risk assessment the best we can. The pathways into the private water supplies, especially with Borough Pits, but the list of properties here might well add in the other properties. To say there's no pathway between the proposed development and the private water supply, for example, at Dockroyal Farm, can Mr. Robb categorically state that? Can he categorically state there will be no effect to the borehole water when nobody, including Mr. Robb, knows where the source of the water is for Wood Park Farm? Can Mr. Robb categorically state there will be no damage or interruption or pollution to the water of the ward of Cairnlea when it was stated originally in the original risk assessment? Nobody knew where it was. It was discounted. In fact, I don't think even ward of Cairnlea was actually in the first risk assessment. Can he categorically state, with his qualifications, unlike me, unqualified, can he categorically state, and if he can categorically state, can he show the proof? And what proof is that? There's not enough evidence here for anyone to be able to say they won't be damaged or disrupted. That's
well, we'll leave Mr. Robb to speak for himself. But what the reporters can take from your evidence to the inquiry so far is that you alleged a number of properties were missing from the risk assessment. Mr. Robb has now risk assessed them, and you present no counter evidence to his conclusions regarding risk assessment for these properties.
Well, maybe I haven't presented it correctly or fully enough for you, but to say to simply state there is no pathway between the proposed development and the private water supply for one, two, three, 4, 5, 6 of the properties, and 2 of them stating with mitigation they should be fine. I don't think there's enough evidence given. Now, evidence that he is incorrect, it's not for us to evidence that he's incorrect. It's up to the applicant to prove they won't damage through the proposed development in the future. I note also in those tables that has been provided on the properties that were missing or not fully looked at. The hydraulic connectivity between established and proposed development for East and West Altacanic and High Altacanic, Glenalty House and Glenalty Cottage don't lie downstream, but it states there's no pathway between the proposed development and the private water sources, and yet they take their water from Loch Alty. Which gathers water in a basin from a catchment area which is massive roundabout. So where is the proof?
Well, at the end of the day, do you accept, let's take a step back from this, do you accept that it is for the reporters to judge ultimately whether Mr. Robb's evidence should be accepted or whether your concerns that his evidence is insufficient is enough to discount his evidence? Is that a fair way of looking at it?
Yeah.
Don't answer the question for a moment. I shouldn't object to cross-examination, really, but that is hardly a fair question for this witness, who is not qualified and is not a reporter. So she doesn't know what other considerations the reporter is going to put in the balance. Ma'am, with respect, this is not a fair question for this particular witness, and it should be withdrawn.
Well, the witness has answered the question already. If Mr. Campbell wants to make submissions about it in due course, that's fine. But I was asking for her understanding of the process. And at the end of the day, sir, ma'am, I will be submitting that it's a matter for you to determine whether Mr. Robb's evidence should be preferred to the council's lack of evidence. That's the nub of the issue. So I'm content to move on.
Okay. Can we leave it at that?
I wonder, Ms. Lobban, whether you've received the conditions yet, because now is probably an appropriate time to have a look at those if you have them.
I haven't, no.
They have been sent, ma'am. Ms. Lobban, do you have access to your own email there where you're sitting?
It's in front of me and it's not through, it's not here.
Well, I'll tell you what, let's come back to that then, and let's move on to a slightly different issue, which is the water intended for human consumption private supply Scotland regulations 2017. And I just wanted to have a look at those regulations with you. It's document CD 14.9. Do you have those?
I've got the my own copies of the regulations, etc., but I don't have the document CD 14.9, whatever it is you've.
That's okay, as long as you've got a full copy of the regulations, that's fine. Sir, ma'am, just checking you've got copies of that. Yeah. And In your statement of case, and in fact, I think recognition, you'd referred to Regulation 16.
That's correct.
Ms. Loban.
That's correct,
And
yes.
that's the section headed duty of care. And it reads, a person in relation to a supply of water must not take any action which has the effect of allowing any deterioration of the quality of the water insofar as that's relevant to the protection of human health. So that's a restriction on taking action that will have an effect, isn't it?
Yes,
Yes.
A person in relation to the supply of water,
Yes. It's not necessarily something that's relevant to this inquiry, which is more about understanding the likely effects of the development. It's more about what happens on the ground. Would you accept that?
I'm sorry, could you say that again? could you
certainly.
just repeat that?
Yeah. So my question is, this regulation is really about what happens on the ground. It's about physical acts or things that are done that have an effect, rather than something that's strictly relevant to the issues before this inquiry. In other words, the reporter's consideration of what the effects might be of this development taking place.
No, I disagree. I think it's Scottish legislation that underpins the whole reason why we're sitting here today.
Okay. So
maybe I'm not getting you correct. Maybe I'm not. Maybe I'm taking it the wrong way, Mr. MacLeod. But that's why I asked you to repeat it. But as the question I've been posed, I mean, it's the underpinning legislation. Now that's what we all. Everything's underpinned by legislation that's enforceable. So if this wasn't enforceable and it wasn't necessary to make applications and get permission, we wouldn't be here today. So no, I would think it underpins, it's one part of the underpinning legislation of the reason of why we're here today.
Let me try and put it to a slightly different way. Regulation 16 doesn't apply to the reporters, does it? And Mr. Campbell may want to object on the basis that that's a legal question. It might be a matter for submission.
I don't want to question.
No, I don't think it applies to the reporters. No, it applies to anyone who is going to the relevant people, the relevant person. That's
to do something on the ground. That's really the point I was trying to get.
A relevant person doesn't have to be a person, though. A relevant person can be a company, and it doesn't just apply now here in time, like you're saying, on the ground. It applies in the future, but it also applies prior to. You have to take a duty of care. You've got to look at everything. And I'm not saying you're not doing that as a company, and I'm not saying that Mr. Rob's not doing that as his environmental risk assessment, but I would say it's not just applicable on the ground, it's the underpinning legislation.
Yeah, I suppose it may be helpful if I try and explain what I wanted to discuss with you, or the reason I'm discussing this with you. What I'm trying to ensure is that the reporters have a full understanding of the various regimes that apply and how they might apply in practice. So let's park my previous questions for a moment, and let's take a scenario where the wind farm is consented. At that point, the duties in Regulation 16 would apply to anyone involved in the construction of the wind farm, wouldn't they?
It would, yes, and the companies behind.
Indeed, and I'm not, when I refer to person, I accept that means legal persons, companies as yes. Well. So there's an underlying duty, or an overarching duty, whichever you prefer, not to do anything which has the effect of allowing deterioration of the quality of water.
That's correct.
We then have some of the powers that are available to the local authority, and I'm sure you're familiar with them, but if you could turn to Regulation 32. That reads, where an enforcing authority, so just for context, that's you, that's South Ayrshire Council. Yeah.
Yeah.
Yeah. So where South Ayrshire Council reasonably believes in relation to a supply of water to a point of compliance in its area, and I think point of compliance, keep me right, that's the property effectively, the property that's served.
Sorry, I can't get the page. Sorry, just if you just say it to me again, I can't get the page.
Yeah, sure. So when it talks about the point of compliance, I think that's referring to the property. So in essence, what it's saying is where the council reasonably believes that something's happening to a supply of water to a property, and where it believes.
Sorry. No, sorry.
Yeah. Okay. So what it goes on to say, where the council believes that a person has contravened or is contravening a requirement of the regulations, or has failed to comply with the regulations, and that as a result there's a significant risk to public health or the quality of supply of water, and that urgent action is necessary, the enforcing authority may take action in accordance with this regulation. So there's an overarching power for the local authority to step in if it believes that something has gone wrong and there is a risk to public health or the quality of a water supply.
If there's a risk to the water supply, yes, but enforcement power can be taken to it's not just at point of compliance. The point of compliance is not just a property, I should say. Point of compliance can be tanks or other points out with properties, because not all properties have the point of compliance that we sample on the property.
Yeah.
So
the point of compliance, to some extent, may be a bit of a red herring for the question I'm asking. I suppose what I'm really coming to is, if the council believed that the applicant was in breach of the regulations because it had taken action which allowed the deterioration of the quality of water. So if the council believed that the applicant had done something that had resulted in a deterioration of the quality of the water, this regulation allows you to take action, doesn't it?
yes, it does.
And if you go on to 32.2, which is at the top of my page 19, it says the enforcing authority may serve on the person an emergency notice requiring the person by such date as the notice may specify to take such steps as the notice may specify, being steps which the enforcing authority consider necessary for the purpose of reducing or removing the risk referred to in paragraph 1b. So in layman's terms, what we have is, if the council believes that the applicant has done something that's caused a problem, the council can serve an enforcement notice, an emergency notice, I should say.
That's correct.
That tells the applicant, presumably, to stop what they're doing and could specify further steps to remove the risk.
They could, yeah.
Yep. If you look next at Schedule 7 to the regulations, please. And they're on page 47 of my copy. And we don't necessarily need to go through all of the detail of this, but if you're familiar with it, have you got that there?
Yes, I have. Yes. I have.
Yeah. If you're familiar with it, would you agree that the essence of this, the power to serve an enforcement notice, is that where there's been a contravention of the regulations and the council thinks it's likely to happen again, the council can serve an enforcement notice to prevent that from happening.
It can, yes.
So it's retroactive to the extent that it's triggered by the fact that there has been an event. It's then, I suppose, proactive in the sense that it could put in place restrictions on what could be done going forward to avoid that problem from happening again.
It could, yes, and it is, and it could, yes. But I would also add that that's probably the reason why we're sitting here today, Mr. MacLeod, because rather than go down the enforcement route, which none of us want, nobody really wants to do, it's better to solve problems and to have problems occur and then try and sort them, because not all problems can be mitigated. So the enforcement, yeah, does, and it can, but we don't want it.
I agree entirely, and my clients agree entirely, that they do not want enforcement action to be taken. And if you'd had, this is no criticism of you, but if you'd had the conditions available to you, we would have gone through the sequence of events where we can see the protections in place to ensure that problems don't occur in the first place, and that we only get to the 2017 regulations in an extraordinary event where the conditions have not been complied with. But we will come back to the conditions once they arrive from Mr. Campbell.
Right, they've come through now, actually, just as you're speaking.
They have, right. Well, I'll tell you what, before we get to them, let's just finish off very quickly with the regulations and Schedule 6, which we skipped past. And Schedule 6 is a different form of notice. They're called remediation notices.
Remediation notices.
What we can see from Para 1 of Schedule 6 is that where the council reasonably believes that a supply of water to a point of compliance poses potential danger, has failed to meet one or more water quality standards, or is failing to meet one or more standards, etc., the enforcement authority may serve a remediation notice on a person who, in relation to the supply of water, is a relevant person. Now, a relevant person is basically somebody who has control of the area that the water supply comes from, as I understand it.
It can be any relevant persons can also be in the properties as well, but relevant persons are different to the responsible persons. The responsible persons are within the actual confines of the boundaries of the properties, so to speak, but the relevant persons, it can be wide ranging. It could be absolutely anybody who has anything to do with the catchment, the supply line, and the tanks if they're out with the property.
So in this case, would it apply to the applicant if the applicant has control of the land within which the private water supply is sourced from?
Yes, and if the applicant was, say for example, yourselves as applicant are doing the development, but you are renting the area from a landowner, for example, the landowner could be liable as well. So if you're not the landowner, it can encompass whoever's the relevant person more than.
I think we're in agreement here that the point is it's a wide power, and a relevant person could include a whole number of people, including the applicant people, in consent.
Yeah.
And the point then is that if we,
I'm sorry, the signal's breaking up, Mr.
points in a wide range. Can you hear me okay now?
That's better now. Could you repeat the previous questions?
Certainly. Certainly. So can you all hear me okay? All hear me okay? Yeah.
It's still slightly broken at my end here, but
Let's I'm just
Yeah.
so
You've gone again, Mr. Cloud. Cloud still breaking. Maybe turn.
Is that any better?
Maybe turn off. Sorry, Mr. Cloud, maybe not. I'm not working.
Video's been turned off.
sounds better.
Can you hear me?
Yeah, if you try now, it's
Is the sound-
yes, we can. Can you hear us?
That's fine. Yes, I can. I'll try without the video on. Right. Where were we?
Thank you.
So the point is, if the facts in paragraph 1 apply, so if the council believes that it's a potential danger to human health or that water quality standards have failed and there are problems that are likely to continue, then a remediation notice can be served on a whole host of people, including the applicant. Agreed?
That's correct. Correct, yes, agreed.
And the remediation and the remediation notice, you'll see from paragraph 3C, a bit further down the page, must set out the steps which the council requires the person to take for the purpose of protecting human health, including where appropriate action to prohibit the supply of water or restrict its use or provide an alternative supply of water. It can require the restoration of the quality of the water supplied, and it can also require measures to protect the quality of the water supplied so that it meets the water quality standards. Now, those are extensive and wide-ranging powers that the council could use against the applicant if the applicant had not fulfilled its duties under the regulations, couldn't it?
Yes, that's correct.
Yeah. Okay. I think the final question, and we'll come back to the conditions in a second, but the final question I had in relation to the 2017 regs is perhaps have a look at Schedule 1. And Schedule 1 is on page 23 of the copy that I have.
Yes, got it.
Now, taking it short, Schedule 1 is basically saying that by 1st January 2022, you'll see that date in 1C.
That's correct,
Yeah. So by 1st January 2022, you, the council, must have a register that contains all of the information that's listed below. Is that correct?
That's correct, yes.
And in practical terms, that means that by this time next year, you will have a comprehensive record of every private water supply in your area.
We should have.
Well, I'm assuming you will have, because it's a duty on you to have it done by
There
then,
is a
isn't it?
duty, but we're also in the
Yeah.
middle of a pandemic right at this present time as well, and our work has been cut and redirected onto the COVID because environmental health are, as you would expect, dealing with public health. So it's not just myself who does the private water supply systems in South Ayrshire Council. Other officers are normally involved, and there's a team of us Although I do the main part, there is a team of us. However, we're also getting training from DWQR. In fact, I'm due to go on training this week, coming, sorry, and further training, which I haven't been able to get onto because my workload has been such that I've had to prioritise due to the pandemic. So, although it states by the 1st of January 2022, I'm not sure that every local authority in Scotland will have that completed by that time.
Okay. Well, I'm not expecting you to commit the council to anything here, but can we agree that at the very least there's a legal duty on you to have a comprehensive record of all private water supplies in your area, including those relevant to the application site?
There is legal duty, yes.
And that comprehensive record would include all of the things in paragraph 2, which include volumes, sources of water, the purpose for which the water is used, all of the things that you are concerned about as part of this application.
Yes, that's correct. And I can say there are risk assessments in the old format still. We do have risk assessments for most of the properties, not all of them, but most of them.
Yeah.
Some are partial, simply because we haven't been able to complete them, but we do have risk assessment for most of the properties. The ones in high focus, they've been done more than once, as far as I'm aware, and more than by myself.
And just on the subject of risk assessments, if you go to Regulation 10, which is on page 11 of my copy,
Yes.
we can see there that the council must carry out a risk assessment in relation to water introduced into and supplied through and from each PWS to premises in its area to establish if there is any risk that the water could pose a potential danger to human health. And again, that's to be completed by 1st January 2022 as well.
Correct. It's all come in with the new legislation. Well, the updated legislation, I should say.
The regulation goes on to set out the way in which the assessment must be carried out. So if you look at 4, Regulation 10.4, the assessment must be carried out in accordance with a method approved by the Drinking Water Quality Regulator, must be based on general principles, etc., etc. But those are duties on the council. They are not duties on the applicant, are they?
No, their duties on the council, and it's the enforcement body.
And unlike, sorry.
No.
Okay. Unlike Dr. Connor, you don't suggest that the 2017 regulations impose duties on the applicant in the form of the risk assessment that must be undertaken, do you?
I think it depends on who the developer is. For example, the forestry, it stipulates they should be taken, as far as I'm aware, they should be doing the risk assessments, the DWQR, but it would be best practice, I would expect, to follow the lead of the DWQR and this legislation. It would be best practice to do the risk assessments.
Well, I think we've covered this already, but you've not been able to point to any piece of guidance that says that, have you?
No.
And as a recently introduced piece of legislation where people are finding their way and looking for as much guidance as possible, you would expect to find that if there was a duty on the applicant to undertake the risk assessment in that way, wouldn't you?
Well, there is a whole part on the risk assessment of water supplies within the legislation. So the enforcing authority, and it does state it's the enforcing authority.
Yeah, okay, thank you. taking account of the risk assessments that you've got to do and the register that you've got to maintain, and actually, sorry, there is one other point. Beg your pardon. So if you go back to Regulation 8, just on the page before. In fact, maybe just start at the top of Part 2 there. So what we can see is you've got to maintain your register of information. That's Regulation 5. The contents of the register are to include the things that we looked at in Schedule 1. That's from Regulation 6. You have to review the contents of that each year in Regulation 7. And then there's a requirement in Regulation 8. And I suppose, so for 5, 6, and 7, the duties are on the enforcing authority. That's for you to do. When we get to Regulation 8, it says where water is being provided or intended to be provided to premises, etc. Each person who owns the premises must ensure that the enforcing authority has been provided with all of the information relating to unrecorded part which the registering authority needs in order to comply with its duties under this part. So in English, as I understand it, what that's saying is, if your register is incomplete, there is a duty that shifts to the owner of the properties to provide you with all the information you need to make sure that you can have an up-to-date register.
If it's an unrecorded section of the, for example, if it's change, if the change of use or introduction of an extra tank, or the switch supplies from a surface supply to a borewell, for example, or there's a change, basically, that's normally what we take that as. Along those kind of lines, yes, there is a duty then.
So I suppose to summarise,
something that's not been recorded by us, some part that's not been recorded to us, or a section that's not been recorded to us, or a change, for example, an estate perhaps changes the way it treats the water, and it runs, maybe has more than one supply because it's a big estate working on different things. So they change the way this has happened, taking this from real life, a change of treatment, and they merge two supplies into one for a holding tank to get pressure and to safeguard against drought, for example. That's an example, one example.
Yeah, that's helpful. So to summarise, by the time, all being well, by the time we get to 1st January 2022, there will be a comprehensive record of all private water supplies in the vicinity of the application site that's publicly available.
Question, and I'll give you the same answer. The answer I gave before is there should be. I don't think every local authority in Scotland will be able to. We are in the centre of a pandemic, COVID-19. Officers have not been working on their normal duties for a year now, and yes, it states in law it should be. However, I think all the local authorities will be asking for extension of time.
Mr. Little.
Thank you, Mr. MacLeod. We had a question about the regulations. Well, we had a few, and we've covered quite a lot of them, but I'm just going to ask one because it's relevant at this point, just to save asking Ms. Lobban to go back over it again. Can we, and it's just about this, you used the word comprehensive there. Can we have a look at Regulation 2, which is on page 4 of the PDF, if that's what you're using? Okay. Do you have that, Ms. Lobban?
No, I've got a paper copy. I've got the hard copy.
Right. But you've got Regulation 2 there in front of you. Yeah.
I've got well.
It's entitled. It's application.
sorry. It's in part 1. Okay, yes, I've got it.
Okay, great, thanks. So under 2.1d, which is just 6 or 7 lines down from the start, says, sorry, let me go back. Regulation 2 right at the start says that subjects to paragraph 2 and 3, these regulations, except part 10 and schedule 10, do not apply in relation to, and then it gives a following list. And D is water which is exempt from the provisions of these regulations by virtue of paragraph 4. And so if you go down to paragraph 4 of regulation 2, which is in the middle of the next page, so this is what's exempt. Water supplied from every part of a private water supply system, which either or both provides in total less than 10 metres cubed of water a day as an average, or serves in total fewer than 50 persons. Now, I'm happy to be put right on this. We wondered whether that the implication of that is that individual private water supplies for a single dwelling, and in fact possibly for more than a single dwelling, would be exempt from the regulations, and that therefore you wouldn't need to do a risk assessment under the regs for those types of PWS. Now, if I'm misunderstanding it, that's fine, but I just asked the question now since it's opposite to what was being talked about there. So I don't know if you've got a view on that.
Well, I can't find it in the. I know what you're describing there because I work with it, but I can't see it in the writing. I don't know where the section 4 is. But I think what you're trying to define is the difference between type Bs and the large supplies. Is that correct? The small supplies and large supplies, or the 2017 regulations and the 2006 regulations? Is that correct?
I'm not sure. So let's. You had regulation 2 there, and we looked at 2.1d, right? So the part I was referring to is in the page immediately after. So it's page 5 on the printed version of the regs.
Okay.
And so the top of that page is F, G, H, then 2, then 3, and then under 4.
Oh, got you.
Yeah, and so this is what's exempt from the regulation. Oh, this is what I read to be exempt from the regulations. And it gives 2 examples there. PWS supplying less than 10 metres cubed or serving less than 50 persons. So I just wondered whether that meant you wouldn't be doing risk assessments for those type of PWS because you don't have to under the regulations. And so that's a question. Have I got that wrong?
No, you're correct, but there's changes. I believe there's changes coming into the 2006 regulations as well, which cover this particular type of supply here. I've come up against, I won't say problems, I'll say issues which I've had to try and resolve in the past 2 to 3 years. Basically dealing with small supplies or type B supplies, which are less than 10 cubic meters or less than 50 persons. The supply, the type B supply, still imposes a duty of care, and it still requires a risk assessment to be done, but not every year for the reporter, the same as the large supplies do here that Mr. McLeod was referring to, that the register, if you like, has to be reported every year. For example, I'll have to fill in the report for the DWQR for the large supplies to be submitted for the beginning of April this year. But we don't have to do it at present for the small supplies, which we call class type B.
Okay, so it's the small supplies I'm interested in because I think the point Mr. McLeod was trying to make is that there will be this comprehensive survey by 2022 of every single private water supply around the wind farm site, and you seem to be agreeing with that, although you did make the point about COVID, and I accept that qualification. But are you saying actually that's not correct? You don't have to do such a comprehensive supply survey, although you may do as a result of subsequent changes that are anticipated to come into the regulations. I'm just trying to understand how comprehensive it needs to be just now. And let's say of the 20 or 30 PWS which are in the risk assessment, is it the case that a large number of them won't have a risk assessment done by the council on them because they don't have to have one under the regs?
What you're alluding to is a legal requirement to do one for every single one of the private water supplies. No, it's not a legal requirement to do one for every single one of the water supplies for Mr. McLeod. To answer Mr. McLeod's question, or to answer your question as well, it's not a legal requirement because some of them are classed as private residential supplies. For example, one property, one family, one residential unit on a borehole, for example, or so it can be any supply, surface water, whatever. But anything that's classed as a large supply, whether it's commercial, whether it's tourist, whether it's hospital, whether it's whatever, for whatever reason, whether it's over 50 persons or more, whether the volume they take per day, for whatever reasons, whether it's manufacture, they do have to have the risk assessments done every year. And it might be a case of going along, doing the risk assessment, and there's no change. That is the norm. There's no real change, because the businesses are fairly kind of regular and stable.
Okay, thank you. Sorry, Mr. McLeod.
No, not at all, sir. That's helpful. Just picking up on one point, and I think I perhaps understood the same as you, that from what Ms. Loban had said, the council may well do risk assessments for smaller properties as well as the larger ones. Is that what you were saying, Ms. Loban?
When we go to the type Bs are supposed to be done every 5 years. They have a legal requirement to be sampled and risk assessed every 5 years. Volume of work can get in the way of that, and especially when you're dealing with other legislation changes such as this that brings in the need to do the large supplies in the businesses.
That's helpful. Well, let me put the question to you in fairly general terms, and let's not focus on the 1st January 2022 date. But as time moves forward, the council will develop a more comprehensive picture of private water supplies in this area as a result of its statutory duties.
I would expect so, yes.
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 And that more comprehensive picture will form part of the baseline that the council considers when it comes to look at planning conditions.
I would expect so.
Grand. Okay. Let's then turn finally to the planning conditions, which I think you've said you've now got.
CD 24.1, is that correct?
Yes. And to answer Mr. Campbell's question finally, we're going to start with condition 18. And I'm afraid my version doesn't have page numbers.
Okay, now I've got condition number 18.
Condition 18, and hopefully that will be headed construction and environmental. Have you got that one? So the condition begins.
The way the pages have come out, yes, it's at the bottom of the page rather than the last page rather than the top of the page. Yeah.
Okay. So condition 18 is to do with a construction and environmental management plan. It says there shall be no commencement of development unless a construction environmental management plan outlining site-specific details of all on-site construction works etc., together with details of their timetable, has been submitted to and approved in writing by the Planning Authority in consultation with Nature Scot and SEPA. So, taking this one step at a time.
Where does it say that? Sorry, oh yes, I see it, the development. Oh yes, approved and read, planning for consulting in consultation with Nature Scotland. Sorry, I thought you said to SEPA. No, it's in consultation with SEPA. Okay.
Yeah. So, before anything happens on site, before any development takes place on site, this construction and environmental management plan must be approved by you. Agreed?
By environmental health, not necessarily by me. Yes.
Oh, yeah, okay, sorry. By you, I mean you, the council, but I would expect, given your expertise, you'll be heavily involved in the approval of the CEMP. Is that fair?
That's fair.
Yeah. And just looking down the various list of things that would be relevant to impact on private water supplies, I just wanted to run through them and make sure that all of the issues that I've identified as relevant are agreed with you. So Part A, Site Waste Management Plan, dealing with all aspects of waste produced during the construction period other than peat, including details of contingency planning in the event of accidental release of materials which could cause harm to the environment. That's a protection to the water environment and private water supplies, isn't it?
It is, yes.
Yeah. Then B would also be a protection and relevant, is details of how the construction compounds to be formed, details of the welfare facilities, hard standing areas, internal access tracks, material stockpiles, oil storage, which I know is a concern of yours, lighting columns, any construction compound boundary fencing, all to be approved by you before any development takes place.
Yes.
Dust management plan, although we've not really touched on dust, it is an issue that could impact on private water supplies. So again, relevant under C.
Yes.
D, site-specific details for management and operation of any concrete batching plant, including disposal of pH-rich wastewater and substances. Again, relevant.
Yes.
We can probably take, well, in fact, no, let's just deal with them one by one. E, details of measures to be taken to prevent loose or deleterious material being deposited on the local road network, including wheel cleaning and lorry sheeting facilities, and measures to clean the site entrances and adjacent local road network. That's a measure that would be particularly important for the concerns you had regarding site access, isn't it?
It is, yes. Site access and any points where vehicles may have to stop or start up, for example, especially around fluids that could go into the ground, such as antifreeze or oil seepage or loss through fluids, through pipes or whatever, yeah.
Yeah. Then F, pollution prevention plan, including arrangements for storage and management of oil and fuel on site. So that's more about I think that's more about the bulk storage as opposed to individual lorries, but relevant certainly. G, soil storage and management, a matter that might be relevant, certainly to provide or prevent any water runoff and materials. H, peat management plan, well, we don't really need to cover. I, and this is quite an important one, obviously, a water management plan covering water control, means of drainage from all hard surfaces and structure within the site to be submitted for your approval. And actually, I see the reporters had made some comments on that, which I think we'd agreed to in terms of shortening it. But just in terms of the full thing, you need to approve the water management plan. And for the purposes of the condition, hard surfaces includes all internal access tracks, construction and laydown areas, turbine pads, crane pads, and the details to be submitted are to include the means of protecting surface water and groundwater and controlling surface water runoff, management plan to be implemented in full. So a very robust protection for the water environment.
Yeah, yes, it is.
Yep.
We do ask for an emergency action plan as well in the conditions as norm now, because it's required to know who to contact should something go wrong, and if somebody should be able to be contacted 24 hours, 7 days a week. So we ask that as well, and belt and braces.
Indeed. And we'll come on to the monitoring point in just a second. But so far as that condition is concerned, it provides a substantial degree of protection for private water supplies before any development can take place on site at all.
It does. It provides a substantial degree.
And must all be to your satisfaction. By you, I mean the council.
Yes.
And then condition 27 You got that one available?
Yes, I have.
And that's a shorter condition, but certainly no less important. There shall be no commencement of development unless a water quality monitoring plan has been submitted to and approved in writing by the planning authority. And that water quality monitoring plan must be implemented in full. So again, something that provides substantial protection and something that's entirely within the council's control before any development takes place on site.
We've started requesting that in the conditions because it's a really good way of before, during and after showing the water quality.
Yeah.
At volumes and levels of quality and quantity.
And then finally turning to condition 16, which is the point about monitoring. This is the ecological clerk of works. And again, no commencement of development unless you have approved the terms of an appointment by the company, that's the applicant in this case, of an independent ecological clerk of works in consultation with Nature Scot and SEPA. And it then goes on to set out what the terms of the appointment must do. So A, impose a duty to monitor compliance with the ecological and hydrological commitments provided in the Environmental Impact Assessment Report and other information lodged in support of the application, the Construction and Environmental Management Plan. And you can skip over
the habitat.
Because it concludes and other plans approved in terms of conditions 18 and 24 to 29, which would include the water quality management plan. Yeah. We can then see in terms of monitoring, beg your pardon. So the basic duty to carry out the monitoring exercise, but then in terms of reporting, there's a standard duty in C that the Clerk of Works submits a monthly report to the council summarising the works that have been undertaken on site. So you've got an ongoing understanding of everything that's happening, which is relevant to the issues covered by the appointment.
That's correct, yes. Normally what's in is we ask for weekly monitoring, but instead of getting weekly reports, which would be voluminous and adding to work, we ask for a monthly report to be sent not just to us but to SEPA and whoever else is wanting the reports through whoever's named there, and in this instance it would be SEPA and ourselves, and that way we can collate the information for the previous month and look at how the sample analysis are faring.
Yeah. And then B and D effectively require the same thing but to different people, and in essence it is that the ecological clerk of works must report to the council and also to the company's nominated construction project manager as soon, well, at the earliest practical opportunity. It's described as any incidents of non-compliance with the various plans that have been approved.
Yes.
So to summarise all of this then, the reporters have risk assessment from Mr. Robb, which they will have to form a view on. It sets out what he believes are the likely effects of the development. If they were to approve this development, then before anything could happen on site, the council must approve a whole host of further plans to ensure there will not be any harm to any private water supply.
That's correct.
You accept that?
Yes, I accept that.
And having approved those plans, the company is the applicant is responsible for appointing an independent ecological clerk of works approved by you, and that independent third party's duties involve monitoring compliance with the plans you've approved and reporting any incidences of non-compliance at the earliest practical opportunity.
Yes.
In the unlikely event that those measures fail, the council has default powers under the 2017 regulations that it could take against the applicant. And those measures could include requiring restoration of private water supplies.
That's correct.
Thank you very much. I don't have any further questions.
Okay, thank you.
Thank you, Mr. MacLeod and Ms. Lobin. I think it's probably a good time to take another short break. We had a list of questions. You've covered a large proportion of them in your evidence in chief and your cross-examination. So David and I will just quickly take stock of the ones that we still need to ask you, basically within more sort of detailed points within the wider evidence that you've given, and then it'll be over to Mr. Campbell for re-examination. So it's 2:38. Could we come back at 10:02? 14:56?
I think Dr. Connor wants to first.
Excuse me. Yeah, excuse me, ma'am, but don't I get a chance to ask some questions too and cross-examine the witness?
No, the way that the inquiry works is you get the opportunity to cross-examine the applicant. So your opportunity is the opposing party. So you're on the same side as Ms. Lobin in that you're objecting to the proposal. So your opportunity to cross-examine will be for the applicant.
Oh, okay, because I had some questions that I needed to clarify, because obviously, you know, the residents aren't necessarily the same group as the council.
I think, ma'am, it would be appropriate, if I may say so, if she has questions in clarification, to get those matters out of the way before re-examination. Of course, have to understand that the questions in clarification, not cross-examination.
Dave, have you got a view? That's Mr. MacLeod. Have you got a view on that?
I have a potential difficulty with it. I mean, I appreciate that Dr. Connor may not be familiar with the inquiry process, but as you've said, Dr. Connor is effectively on the same side as the council. If Dr. Connor had questions of clarification which might be legitimate, then they probably should have taken place before I asked any questions of Ms. Loban, because there is now a risk that Dr. Connor, sorry, let me finish. There is a risk that Dr. Connor asks questions of Ms. Loban that I then want to go back and re-examine. And, you know, it's been a fairly long day so far. My preference would be that Dr. Connor simply gives her evidence and doesn't ask any further questions at this stage.
Excuse me, but my questions are based on the answers that she gave you, and I'm not quite clear if that's what she meant. So how could I possibly ask the questions before you'd asked them?
Well, that does give me a difficulty, because it's not Dr. Connor's role to effectively re-examine the witness. That's Mr. Campbell's role if he chooses to do so.
But that will affect the evidence that I give, knowing whether the answers were correct or whether I've interpreted the answers correctly. And I'm not sure that I have.
I think it's quite clear, ma'am, if I may say so, that established practice is that if any third party requires clarification of a witness's evidence across, then he or she should be allowed to ask questions and clarification, not to contradict what the witness has said, but simply to get clarification. That's quite well-established practice, at least in my modest experience. And I don't know if Dr. Connor has a long way to go or a short way to go, but would it harm the process if it took time to clarify what she said she doesn't understand at the moment?
Have you much to ask, Dr. Connor?
No, I basically had 4 questions.
On the basis, Mr. MacLeod, that you could come back to ask Dr. Connor further points, would you be willing to agree to her asking those questions?
I'm willing to agree to the principle of her asking questions. I may have to object to the questions depending on what they are, but yes, if you're content to allow questions of clarification, then I'm happy for that to happen, as long as I have the right to ask further questions if need be.
Okay, that sounds a reasonable compromise. Is that okay with you, Ms. Mloban? We'll take a short break first, and then we'll come back for Dr. Connor's questions, followed by the reporter's questions. We've moved on now, so will we say 3 o'clock exactly? Hello, welcome back, everyone. So I'm conscious that we're now at 3 o'clock. We are hoping to finish around 4. Certainly, we would hope that we'd be able to finish Miss Loban's evidence today. Do we think that's likely from parties? That would be our plan, even if we have to run a wee bit after 4. Is that all? Is that okay with everybody? So we'll start with Dr. Connor with some questions of clarification of facts. I think would need to restrict these two. So if they stray into something further in terms of evidence, either David or I, or potentially the applicant will step in. But over to you, Dr. Connor.
First of all, thank you very much, ma'am, for giving me the opportunity to ask some questions. The first question I had, and I think it would be helpful, if you don't mind, to go to the inquiry report, which we looked at earlier, which is CD 1515. And if you could go to electronic page 37. Okay, so my question is, there was quite a lot of discussion about the footprint of this development, and also I'm very aware that Ms. Loban is not a geohydrologist. Do you need to be, my first question about this is, do you need to be a hydrologist or geohydrologist to assess surface water impacts? I can't hear you.
Sorry, my mistake. I said surface water, the impacts on from.
Well, from a development, do you need to understand geology to understand surface water flows?
Professionally speaking, I think you would need to be qualified in some respect of hydrology, hydrogeology, water geology, I would expect.
Okay.
To have a basic understanding, as I have, my understanding has been from living in water supplies, working in the position I'm in just now, and have been since 2008, but also from my outdoor pursuits, because I was at the Scottish Agricultural College in Ayr, and part of that was changes in land use, and we had to go out and look at land, but we didn't go in depth as as Mr. Rob, you know, we didn't do modules and study as Mr. Rob done for his qualifications.
Okay, I mean, my question, I guess, is more related to the water catchment area for Fernley, Bar Hill Station and Kenley, which you've said is coming from the crosswater, and that map marks it just at
Sorry, ma'am. I didn't ask any questions about that issue at all. And,
no, but if you could.
Sorry, could I finish, please? This is not an opportunity for Dr. Connor. This is not an opportunity for Dr. Connor to introduce new evidence through this witness. She will have her own opportunity to give evidence shortly, but the questions that she said to you she was going to ask were questions of clarification arising from my cross-examination. I didn't ask questions about the catchments.
If you could let me finish my question, I will.
Sorry, Dr. Connor, I do need to step in. If it's any comfort, we have a question about that private water supply, so it's probably more appropriate that it comes from the reporters. I have to agree with Mr. McLeod that this opportunity for you is to clarification of points of fact that came out of Ms. Loban's responses.
The end of the question was basically that Ms. Loban had said that they would remove development elements within a catchment that was affected by part of the construction element, like a borrow pit or a turbine foundation? That was going to be my question, because that was what was asked of Ms. Loban. But I'm happy if the reporters ask the same question.
I can't guarantee that that we're asking the same question, but I don't recall that context coming from Miss Loban. So if you've got any other points of clarification,
Right, okay.
happy to let you ask those.
Okay, so my second question, if I can get through it, is there was a lot of talk about the council's responsibility in terms of enforcement action should the developer breach conditions such as causing pollution of water supplies or environmental water. So my question was actually, given that we had discussed the mitigation before and how there wasn't any public water, how would the council actually get the developer to remedy a defect of the groundwater which had already occurred?
Right, that's quite an open-ended question, but it would depend on the incident that happened or was to happen. It's hard to answer without specific instances and examples, and if you give a specific example, then it narrows it down. But
well, thinking of borrow pit 2, because that seems to have been contentious. So supposing Wood Park Farm again had problems with its water supply relating to activity in borrow pit 2, effectively the change has happened. What would the council be able to do to remedy it?
well, we'd obviously do investigation to find out. We'd be looking at the ECO, the clerk of works, would be looking at who is the responsible person to look at the risk assessment at that point in time. We'd try to ascertain what was happening, when it was happening, and whatever the likely causes were likely to be. Now, that might be quite difficult in water supplies, but then it might be a simple solution. If, for example, it was in other borrow pit, and this borrow pit, every time blasting happened at a borrow pit, there was a problem occurring at a specific water supply or several water supplies, then I think it would be reasonable for anyone to assume there was a link there, but we'd need to find out that link. So how would we do that? We'd need to look at how that could be rectified. It depends on, it's too vast in nature, the question. Basically, what we as a council, what we as environmental health would prefer is the problems don't occur in the first place. So if we could prevent potential problems occurring or stopping of private water supplies occurring in the first place, then that would be the best risk mitigation that we think could happen. So.
Okay, certainly in terms of these questions and helping David and I understand the issues, I think the points you raised you had covered in terms of your prevention rather than protection. Any further questions, Dr. Connor?
Well, I think my further question was regarding the Arnameen access road and how the Kemp and the wheel wash facility would happen without actually building any elements. But I don't know that actually Ms. Loban is able to answer that question. So maybe, I'm sure that will be refused.
Well, that's probably one that you will be able to ask Mr. Robb when you cross-examine him if you need clarification on that. So it's probably a better question for the applicant for Ms. Loban.
Okay, that's fine. Then no further questions.
Okay, thank you. Okay, Ms. Loban, we just run through the few questions that that we have. The first one relates to the role of SEPA. And the applicant has stated that the assessment has been undertaken in line with the SEPA Land Use Planning Guidance Note 31 for groundwater, which is CD 5.1. However, in your recognition, you state that SEPA has no legal responsibility for private water supply. Are you able to help David and I understand what SEPA's role is as a consultee in relation to wind farm proposals such as this?
SEPA deal with everything that's not private water supply. Now, this is where there's a lap over, a merging of boundaries, shall we say, where the private water supplies and SEPA enforcement from South Ayrshire Council and SEPA merge, and quite often we have to work in conjunction, or we have done in the past, have to work in conjunction with SEPA. For the catchments are often wide areas, but from the source uptake, which is the point of collection downwards, it's purely South Ayrshire Council enforcement. And everything out with that is SEPA enforcement. However, the catchment areas are large and wide, so we have to take them into account. We have to look at them as the feed to the private water supplies.
Okay.
But the enforcement for private water supplies is through South Ayrshire Council. For example, if you were polluting rivers, the enforcement would be via SEPA.
Okay, so just a follow up on that is that SEPA's consultation response dated the 9th of January 2020, which is CD 2.19b. You don't necessarily need to get it up in front of us, but what it concludes is that all works are out with the recommended 100 metre and 250 metre buffers that are set out in the guidance note. Do you agree with that conclusion, and what's the implications of that non-objection from SEPA for the council's position?
This has been widely discussed and thoroughly discussed over the past, I would say, 4 to 5 years, not just by ourselves internally in environmental health, but with other local authorities and the DWQR as well. The buffer zones, are they sufficient? Buffer zones, again, if you do like a desktop study, it's easy to see on a map a buffer zone of 50 metres, 250 metres, whatever that might be imposed. It looks impressive. However, when you're on site and out physically within the catchment areas or potential catchment areas, areas that we believe to be the catchment areas, it's not just my assessment, but other officers agree that they're not necessarily sufficient, especially, well, for certain specifics, shall we say, especially, but pollution doesn't know a boundary line on a map, for example. If you draw like the map we were using earlier, for example, like John Campbell and I believe somebody looked at the map as well, and we've got everything drawn on a map with neat little lines, and I've got catchment areas assumed, but that means nothing until you're out on the field, out in the field, on site. Buffer zones, I've come across examples in the past, shall we say, from wind farm applications and other types of applications for development, not necessarily wind farms, and just the placement of the proposed application, a 250 metre buffer zone would not have been sufficient. Would not have been sufficient. You've got to take a whole myriad of factors into consideration. It's not just the topography or the lay of the land. It's not just the soils and the types of ground that you're on. It's not just deforestation. machinery, all the different things included in development, but also we've got climate changes here. We have drought conditions which we've experienced ourselves across the country. We have heavy rainfall periods. There's just so many factors to be looked at, and until you're actually out on site looking at the land from the perspective of the place where the water is coming from, and what, or at least have a view down to where the water is probably going, then you can take everything into consideration. But buffer zones might be good for, a good example might be for tree planting, for example. If you plant fir trees as opposed to broadleafs live and will be left up usually longer, for some of them hundreds of years old. But the trees, in essence, in the first few years will drink thousands of gallons of water. If they're only 50 metres in a buffer zone of 50 metres from a private water supply, and you have masses of these planted, then is that going to affect the water levels? Is that going to affect the water quality, needle drop and acidification?
Okay, I think I understand.
It's wide.
Yeah.
It's a huge.
Correct me if I'm wrong, but I think I understand you're not disputing that the works are right with the buffer zones. It's just that you don't think that buffer zones are an adequate way of assessing the impact. There's other things to take into account.
For example, no, they can be. I'm not saying they're not, and I think Mr. McLeod would agree with this. They're not necessarily bad things to have. They're good. They draw the line, shall we say? But that is literally what they do. They draw the line on the map. It's when you're on the ground and you see the ground, you see where they are and what's going on in the area and what development is coming in before, during and after. And then you have to take into consideration, will that buffer zone be adequate?
Okay, thanks for clarifying that. Got a couple of questions about your map, if you wouldn't mind, which is 16.8. Just in terms of the key, there just seems to be a number of some of the symbols aren't mentioned on the key, so I just wanted to make sure that we fully understand what they are. Have you got the map?
Yes.
For you? Yep. So just clarification, the purple triangle, what do they represent?
They were brought in late. Find one. I'll put that in the legend, so sorry.
There's one just to the south of the Armenian.
Arnhem, yeah, that's it's a type of well, but it's not a well. It's not dug into the ground. It's like a sump well. It's the water collects in an area that's sunk down into the ground and seeping up through. So.
Okay, for our purposes, a type of well is fine. And the purple dots.
The purple dots, they are the bore wells.
Okay, and we're on a theme with the purple. There's a couple of purple crosses.
I didn't hear the last answer. I'm sorry.
Bore wells.
A bore well. Thank you very much.
Purple dots, bore well, and the purple cross.
The purple cross is the point where the supply takes into the supply line. For example, the Altocanics take into, or the Nochicoid take the water into either the tank or the pipes.
Oh yeah, you referred to that sort of source collection point, I think you called it earlier. That's and then there's purple squares as well.
purple squares, that would be a business, tourist business. But also it's a mixture of, I know that Burnside would like to say they have spring water, I think that's what they say, but when we look at it, it's actually, I would say, more a mixture of spring water, surface water.
Okay, thanks for that. It's just to make sure that we had all that information. Next question is just to help us understand the information that's been provided by the applicant to the council. The applicant's private water supply risk assessment states that a conceptual site model has been presented as part of the assessment. Now, David and I were talking about him. Have we seen? Has a model been presented to the council, and if so, are you able to make comment on that? Or
I haven't had visual of it. No, it doesn't mean it hasn't been presented, but I certainly haven't seen it.
okay, we can ask the same question to Mr. Robb to clarify that, but I was just wondering whether that had been presented to the council as part of their assessment. Now, just briefly, sort of following on in terms of the information that's been provided, some indication in the SEPA guidance note that, and I think the information in the water intended for human consumption regulations about information on abstraction rates, and that concern that hasn't been provided. Could we ask you, in terms of from your input, is what the implications of us not having information on abstraction rates before us?
For human consumption, it's, well, obviously a business is going to use more, well, we would assume businesses would use more volume than residential units, depending on the residential household. However, it depends on what the use for the water is. For example, Wood Park Farm, they use the water for their own private residential use, but he does use it for his livestock, because the water is so brackish down there that his animals don't get ill if he uses the bore well, and he supplies all the troughs, so the volume is going to be greater. Tourism volumes, businesses, small food manufacturer like Glenalte, for example, down in the Now Road, they have a small business there, and they need the implications. It could mean the difference between, you know, business or not business. If the water volume was to drop, it can be quite important. It depends on whether it's a business or not.
Okay, that's helpful. And to say, we can also ask Mr. Robb that question.
But household size differs as well, and use differs. Modern use now compared to, I think that's quite an important point, this as well. Modern use is completely different to use of 100 years ago, for example, and some of these supplies are really old, and they have been running well and have run continuously for decades, hundreds of years sometimes, but our use now and our expectations have changed. Human expectations have changed. We have washing machines, we have dishwashers, we wash cars. We didn't have these things many years ago, so volumes can go through. We have baths, we have showers, we wash, you know, personal hygiene. There's a lot happens now that didn't happen before, so volume is important.
Thank you. Just a sort of an overview question in terms of information. You've indicated in your various evidence that you don't consider that the applicant has submitted sufficient evidence in relation to potential impact. What additional information should have been provided, and perhaps in the context of what South Ayrshire Council would normally ask for an application of this type? to try and understand whether what sort of information you would have anticipated should have been provided.
It's open-ended. We would like to see as much information as possible. I would have expected a visit to every property, especially something as large as a development as this. I think it's well within the remit of the company or companies to do that, to enable that. Perhaps contacting us beforehand and going out with one of the officers for site visits, that would be beneficial in the first place. Looking at the lie of the land, doing a risk assessment together would be extremely beneficial, because problems can be raised without the need to go through processes such as this. Looking at alternatives, what alternatives have been given should problems arise, instead of perhaps firefighting, like an example. We've stated there's not enough evidence, but then there's more evidence given as to why certain parts should go ahead. Instead of that, well, are there alternatives? Is there an alternative? Could we remove turbines X, Y, and Z? Could we remove these borer pits and take stone from local quarries and boost local business, but safeguard the private water supplies? Could we remove turbines from positions X, Y, and Z, perhaps looking elsewhere to where there's no properties or no catchments for water? That has a possibility of the potential of being affected in years to come. Are there other ways of working? It's really.
So, were these matters that the council asked the applicant to do at the kind of pre-application scoping stage for the EIA? Trying to understand whether it's the council asked the applicant to do it and they haven't done it, or it's something that's come out at this stage as you've assessed the proposal.
I think it's a bit of both, actually. This is the first process I've sat through like this. As I said to Mr. MacLeod and to Mr. Campbell, it's the first process I've been through, and I'm getting a better understanding as I go through this. But we did ask at the outset for on-site risk assessments, but I don't think all of the risk assessments are on site. A lot of it has been desk-based studies, and reliant on information that can be pulled. Anyone can pull off the internet or other manuals or information, and I don't go against that, but I do think there's a lot to be gained from going out on site and actually conversing with people and with householders, and to why they need the water and what use the water is for, and what effect the development, whatever that development is, not necessarily a wind farm, whatever that development is, what effect is it going to have in their lives? Because a developer and the processes before it come in, they do their work, they develop, they construct, they leave, they maintain, and then potentially at the end of it, they can go away, or potentially at the end of it, they can upgrade and make and place bigger turbines or bigger trenches or whatever. But the householders are totally reliant on the private water supply to live there. A lot of the people in areas across Scotland are trying to run businesses, whether it be tourism, whether it be family businesses, whether
Okay, I think we're maybe straying away from the question, just trying to keep things on time to allow Mr. Campbell to come in for your cross-examination. I'd like to take you now to Mr. Robb's inquiry statement, paragraph 7.14, which, if I remember, is CD 15.15.
Okay.
You got that? I'll give you a chance to read it, and I just want to ask whether you agree with it, and it's for us to try and understand how this proposal for the Arecleoch extension is similar or different to your experiences of the other nearby and existing wind farms in terms of the environmental incidents and monitoring that you do and any complaints that you've dealt with.
Okay. He states that they're similar to those used by the applicant in the nearby existing Arecleoch, Mark Hill and Kilgallie wind farm. No environmental incident reports or public complaints in relation to private water supplies. We had quite a lot of inquiries with regard to the Kilgallie and Mark Hill worries, but to be honest, these are before my time as
Okay,
officer in here. But the fact that we're having an extension now and other wind farms are putting applications in, we have a cumulative effect, and that is the worry. That's a big worry, not just for this one. I know this is the one we're dealing with, but we have to look at it as a whole, as an organism that's growing, because it is.
Do you know if the council objected to those other applications on private water supply grounds?
I have no idea. No, I couldn't answer
Okay.
that. Planning would know. I don't know. I can't answer.
Right. The other question, which you may know, is you obviously referred to Chamorro and the fact that the same access road is to be used for Chamorro as for the Arecleoch extension. Do you know, did the council object to that on private water supply grounds?
No.
No, you don't know, or no, they didn't?
No, it didn't object.
They didn't. Okay, thanks.
I've had another application for change. Whether it goes through or not, I have no idea. But the change is to bring the entrance in through Dumfries and Galloway, I believe. Right.
Okay, thank you. I've got a last question, which David's going to ask, and it relates to the details at Bar Hill Station Road that Dr. Connor was drawing you towards. So, if you're able to get the map up that's in Mr. Robb's inquiry report for PWS 14, which is on page 37 of my electronic copy.
Sorry, which document number are you in?
Still on CD 15.15, so it's Mr. Robb's inquiry report.
I'm losing page numbers after page 25, so it's maps then after that.
Yeah, if you keep going through I'll start at the thing at the top of the maps, and we'll go through them.
I've got has got map 1, map 2, and squares on it.
Yeah, okay. If you keep going through that one, so that's the local hydrology overview. Then we've got local hydrologies map 1, then map 2, map 3, and then we go on to the detailed maps of the private water supplies which the applicants indicated would be affected. So we've got Arnameen, Burnside, Laggish, and the one we want to look at is the PWS 14 Bar Hill train station.
Got it, yeah.
Got it, right. I'll hand over to David then.
Okay, yeah, we were just had a question about this, in particular because it's, as you understand it, it's a supply that's taken from the watercourse, and the concerns you were expressing are about the upstream infrastructure, so the tracks, turbines, so that I think that's possibly new tracks, but certainly upgraded tracks, upgraded watercourse crossings. Now, we talked there about the SEPA guidance in relation to groundwater, and I hear what you said about you don't feel that those buffer zones in that are naturally applicable. I mean, this is different because what we're talking about is infrastructure, excavation, other works in the vicinity of watercourses, which then downstream feed the private water supply. So our question is, are you taking the view if you, and you can see the yellow catchment area in those maps there where some of this work is proposed. Are you taking the view that there shouldn't be any physical works in that catchment area, or alternatively, is there a distance upstream where it's okay to have physical works, or is there a distance from any of the tributaries where it's okay to have this physical infrastructure? Just trying to understand, and your wider point is that you don't have enough information to meet these views, and if that's what it is, then that's fine. But I'm just trying to understand, is there an expectation that you have that's not being met here when it comes to physical infrastructure upstream of that private water supply?
I think the fact that they're wanting to, the requirement is to introduce construction upstream on such an area that has so many tributaries is extremely worrying. There's not enough information. I'll still go with that. However, there are required new access roads, and there will be required new water crossing points. And the borrow pits give me great concern as well. What caused the greatest concern was one of the mitigation points offered downstream should oil, or was it diesel, or was it oil, into the water, they would set up booms, and it beggars belief that that would be put forward as a mitigation for a private water supply. I can't understand that. I don't think enough thought has been gone into this, and I'm not saying there hasn't been a lot of work done, but I don't think upstream, or in an area that's going to be feeding water supplies, the catchment area for a water supply, I don't think there should be, certainly I don't think there should be quarries, I don't think there should be construction compounds, and I don't think there should be anything that the possibility of diesels or oil entering into the earth or the water at all. It should be taken out, removed. I don't know if that answers your question or not.
Yeah, no, it's helpful. So if we take that yellow as the catchment area, your view would be that you shouldn't have any borrow pits in there. You shouldn't have a construction compound. Let's say a water crossing. Are you saying that you shouldn't have a water crossing, a new or upgraded water crossing upstream of that supply? Or are you saying, I just use this as an example, or are you saying that, well, there's not enough information? And if it's the second part, what more information do you need?
Right. If I was saying it was a water crossing, there's probably water crossings there already from the previous forestry, and I don't know what they'll be like. I've seen one or two of them. Obviously, I haven't been through the woods, but the introduction of the vehicles, the types of vehicles that are going to be coming in for the construction of the wind farm are big, heavy vehicles. You've got cranes and crane pads. These are all enormous big machines. They're all diesel powered. They all have oil contained in them. You need compounds to store goods. I know the compounds maybe not necessarily on top of the water supply, but it has to be transported. The machines are moving. The introduction of such drastic change, I think, in upstream of in the centre of what looks like the catchment area for the private water supply, which has extremely good volume of water at present, I think is too much. And if they were going to, if a person or a company was to prove they weren't going to cause problems, there would need to be good concrete proof that they weren't going to do that. They weren't going to cause any pollution or contamination that wouldn't have the drastic effect of completely knocking out the water supply completely. Because if you were to get something like diesel or oil into water, into a water supply, you might never be able to use it again. It's contaminated land then as well. I mean, the issues are just horrendous. So rather than
Okay,
have,
I mean that's fine. I think I understand the point you're making. I don't have any more questions. I'm looking over. I think that's our questions finished. So I'll just hand back to Alison. Thank you.
Yes, thank you, Ms. Loban. That's all the questions that we have for you. Do you want to break before you go back to cross-examination, Mr. Campbell? Re-examination? Are you happy to press on?
Happy to press on if Miss Loban is.
yes,
Okay, Connie?
yes, I'm fine. Mhm.
Okay, over to you then.
It's a 20 to 4, ma'am. I'll bear in mind what you said about adjourning at around 4 o'clock. I wonder if we could begin this re-examination by just reminding ourselves that I only want to discuss issues which were raised by Mr. MacLeod with you. Could you start by turning to the environmental statement, CD 1.2, Chapter 10?
I don't have that on CD, I don't think. CD 1.3 chapter.
Well, for the reporter's notes, I'm looking at CD 1.2, Chapter 10, which is headed.
Can you give me the heading, please, Mr. Campbell?
Headings of what?
Of the chapter.
Chapter 10, hydrology, hydrogeology, geology and soils.
That's one I've got in hard copy, I'm afraid. Okay.
Pardon?
Yeah, I've got it now.
Thank you. Could you turn to the second double page, paragraph 22.
Okay.
Thank you.
Is that under field survey?
It's not under a chapter. Yeah, field survey. Yes, it is. Chapter 20, paragraph 22 tells us detailed site visits and walkover surveys have been undertaken by SLR Consulting and MacArthur Green on the following dates.
Yes.
And the last bullet point tells us that on the 5th and 6th of February and the 12th of April 2019, private water supplies, GWDTEs, and watercourse crossings were surveyed.
Okay.
So that's 3 days. Do you have any comment on the adequacy of 3 days to survey the private water supplies that we have been discussing?
Mr. MacLeod very rightly pointed out, very correctly pointed out earlier on today that the DWQR require, as a lawful requirement, 2022 risk assessment of all the private water supplies, classed as large supplies. Would 3 days give me enough to risk assess that entire area? No, is the short answer.
Thank you.
How many people went out in that risk assessment? Was there one person? Was there a team of people?
Let's not speculate. It was quite a simple question. You answered it. Thank you.
Okay.
Now, you've placed a certain amount of emphasis in your evidence on the protection from disruption from harm being caused to private water supplies. Could I ask you this in an example? Suppose a wind farm is built and downhill from a turbine there is some years after construction and the occupant comes to you. Who takes the initial responsibility for understanding what the cause of the problem is? Is it A, the council, B, the applicant, or C, the occupant of the premises?
The question, as I understand it, in 10, did you say 10 years? Because your mic went a wee bit.
I was using it as a metaphor, a period of years post-construction.
Post-construction, number of years later, problem arises. We'd have to do a risk assessment and try and assess what the problem is. The first thing we would do is sample the water and ask for the lab to analyse the water and find out what's going wrong, unless it was something extremely obvious, like the water stopped or there was mud pouring out, and then we'd need to look at what's causing the problem. We'd start and go along the supply line. If there's nothing obvious there, that there's no pipes been dug up, there's nothing happened, or nothing's been introduced on the land, then we'd need to go to the construction, the company, the developer, whoever they may be.
My question was, whose responsibility is it to try to ascertain causation? Is it yours, or the developers, or the occupiers?
The developers.
What if the developer says, well, very interesting, Connie, but nothing to do with us, so we're not taking part in this at all?
We'd need to then look at enforcement in some way, which we don't.
You can't enforce anything, can you, unless you can prove causation?
Well, if it's coming off land and the person's water supply, they would have to look into. They'd be a duty bound to try and find out the cause of the problem.
Yeah.
Because it's not the householder. If it's not the householder, and it's not anything obvious happening, like a tank has broken or a pipe has broken, and
I understand that, but you told us earlier on that groundwater can move slowly, and that it may take some time. You talked about 1,000-year-old water. Well, we won't be here in 1,000 years, but let's suppose it's 6 months. The turbines are built; they're turning away quite the thing. The tracks are only in use by maintenance. There's no complaints, and suddenly a householder downhill says, "Oh, I've got magnesium in my water, or I've got a compound in my water, which is making me ill."
well,
Who is the responsible person for ascertaining the causation? Because an occupant will expect you to do something, Mr. Lobban, won't he?
Yeah.
And
well,
am I right in understanding you can't do anything until you understand the cause of the incident?
Because the nature of the problem, that's correct, and that's why we would start sampling. The first thing we would do is take samples. Take samples at the point of use, take samples possibly from any tanks or holding, take samples from any source point uptake that we know of, and we'd have to take it from there. I mean, it's such an open question because it would depend on what the problem was, but there is a duty of care upon the developer.
Is your position, if we understand it correctly, that protection is better than punishment or some preventive later action? You want to achieve protection.
Yeah, I wouldn't call it punishment. No, that's the reason why Environmental Health and South Ayrshire Council look at developments and applications of all kinds with the private water supplies, or we try to do our best. For that very reason that you've just given there, Mr. Campbell, because when it comes later down the line, if people have fallen ill or things have broken down in the house, as we've had because of contamination through grit and silt, or other things are evident, like you're saying there was compounds evident in the water or whatever, sorting it out is a legal nightmare. So why not look in the beginning and protect and prevent?
You can't, for example, serve a remediation notice under the regulations, can you, until you know what has to be remediated?
That's correct.
Yeah, and the same is true of an enforcement notice.
That's correct. We could.
That's true. That's true whether it's. Sorry, let me ask the question. That's true whether it's a water question or a noise question, for example? Might be a noise question, and liability might be denied.
That's correct.
Yeah. Okay. Thank you. Now, have I understood? It's just my fault for not getting it in the notes properly. But are you saying that, in your opinion, the duty of care, as it's expressed in the WIN-370-17 regulations does fall on the applicant.
Duty of care does fall on the applicant, yes.
Thank you.
And am I allowed to just add in to that?
No, I don't need you to
questions?
add anything to that. Thank you very much. Could you go back to 1.1, chapter 10? Sorry, I should have taken this from you earlier.
Of which document?
CD 1.2, chapter 10, hydrogeology, geology, etc. I know you're tired and I'm nearly finished.
Oh, no, I'm trying to think which document that everybody says CD point, but I'm going by names here.
I think you have it. I think you have it as a hard copy. Hydrology, geology.
Okay, thank you. Got it.
And to paragraph 217, please. 217.
Got it. Yes, 10.5.
10.5, summary and statement of significance. Under potential effect, we have construction, pollution, erosion, and sedimentation, significance of effect before, negligible, proposed mitigation, good practice techniques, confirmatory water quality monitoring, significance, negligible. Now that was the applicant's summary, wasn't it, after the work that it did?
It appears so, yes.
And that's what you were presented with as a local authority.
That's what we are presented with, yes.
Yeah. Do you agree with that conclusion?
No.
Again, it's my notes and I'm sorry. Does the DWQR issue guidance to local authorities about assessing effects on private water supplies?
Yes, it does.
What is the guidance? Is it a manual or is it simply generic guidance?
No, it's technical manual is there online for everyone to look at. Also, we have different communication, internal communication, like training and updates from DWQR as well as
So
authorised offices.
Sorry, say that again. Would you say internal communications?
From DWQR, such as training and updates as authorised officers.
Sorry, bear with me a second. Thank you very much, Ms. Lobban. I'm grateful to you for your help. I'm sorry you've had such a long day, but at least you won't have to come back tomorrow. Ma'am, thank you. I've finished with Ms. Lobban now. I'm most grateful.
Thank you, Mr. Campbell, and thank you, Miss Lubin. That's probably a good place to start or to stop for today. We haven't made as much progress as perhaps we thought whenever we allowed 2 days for this inquiry. I think even if we started half an hour early tomorrow, I think we're still going to need to go into Friday. We have Friday allocated as a catch-up day for this week. Is everybody available on Friday?
Yes.
On that basis, I suggest that we just start as arranged at 10 a.m. tomorrow, and that would be with Dr. Connor's evidence, and see how far we get through that. We may get a chance to start the applicant tomorrow as well, and have a shorter day as possible as we can on Friday. Mr. McLeod?
If it's any help, ma'am, I think that a lot of issues that I might have wanted to explore with Dr. Connor tomorrow have been addressed today, and I would not expect to have to take as long with Dr. Connor tomorrow as certainly not as long as we took today. So I think we'll make better progress tomorrow. To some extent, the first day of an inquiry session is always going to be a bit more laboured because there's a bit of laying out the groundwork, as it were. And I think I'm certainly hopeful we'll make better progress tomorrow.
That's good. That's helpful, but I still don't see that we'll get through Dr. Connor and Mr. Rob tomorrow. So it's useful to know that everybody's okay for Friday. And I think if we have that in the diary, and we'll use it if necessary. Is there anything else from anybody before we stop today? If not, just thank you very much, and see everybody at 10 a.m. in the morning.
Okay, thank you.
Thank you.